Good morning, Mr. Commissioner, members. We are still busy with the testimony of Mrs. More. She's now on page 16 of her statement, and she will now deal with the AO transaction.
You remember the oath you took yesterday, Ms. More?
Chair. Yes, Commissioner.
I think let us freshen it up, or let us take a fresh one.
Okay.
Can you please stand? Do you swear that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth? Say so help me God.
So help me God.
Thank you.
Thank
Be
you.
seated.
Morning. Yes. Before we go to IO, there's just a couple of things I just need to follow up on, Advocate Lube, or to ask further. The first question, Ms. More, is on, these are just broad questions, and then I'll come to others. But the first one is on the cost structures of the PIC, since you're the finance person there. There are a lot of vacancies at the PIC, and I think you mentioned that the profit figure is like 10% of the sort of the revenue, isn't it? Yeah. Why are there so many vacancies, and has that got to do with managing costs or not? That's the first question there.
So, thank you. Just to highlight, so the 10% management fees is the commitment that we've made to the shareholder that at any given point in time at the end of the financial year, the net profit will be at least at 10% of management fees. As it stands, it's actually that number is beyond 10%. So regarding vacancies, so on an annual basis, managers identify the critical positions that they want to recruit for that financial year. Then they drive the recruitment during that year. So if you refer back for budgeting purposes, we always budget at least 40% of management fees, which is the target that is set, the financial sustainability ratio that is set, that is at 40%. So it's always been budgeted at 40% of the budgeted management fees.
So are you saying that the managers bring in the positions and if they don't bring them through, they don't get filled, or are there any cost containment measures?
So with regards to, so let's give an example. So let's just say a manager during the course of the year, they identified that there's a position that they hadn't anticipated to recruit and they need to recruit. There's a process of requesting that they go about and request that additional position. So it's driven largely from the managers in that they identified the positions which they believe they need. So because it's in the whole org structure, and we just managed to make sure that it's within this financial sustainability target of 40% of management fees.
So meaning you can go on for some years without filling the org structure in general?
I'm going to answer it differently. So the key things, what we've done in the last year, there's certain departments that it's blatant that they are very under capacity. So I'll name risk. Risk is very under capacity, especially with the credit risk, and the next tier of the structure being the general managers had not been recruited, which is one of the things I earmarked with the then acting executive head of risk, that we need to fill up that top structure because it's quite an important team, because an assurance provider team. So what happens is the managers drive what they believe is the positions they need, and they're the ones who trigger the process of recruitment. So they'll fill in the necessary form and submit to HR and indicate to HR that they need to commence with the recruitment. So it's driven by managers.
Yeah. So are you saying that we shouldn't worry too much if the org structure is not 100% filled? Is that what I'm hearing?
Okay, and I apologize, Commissioner.
Yeah.
Okay, I'm going to answer it differently.
Yeah.
You should worry when it's critical places that are highly vacant. So you don't need to be at 100% at a given point in time, but you must make sure that you're operating efficiently and effectively, and understanding that the key critical areas that are quite core to the business and that are critical for sustainability, and making sure that governance at its peak are actually recruited. Hence why I've made an example of the risk department. So for me, it is a concern that we need to beef up that team and fill it up.
Okay. And broadly then, where do you think the org structure should be? Like 50%, 70% roughly on a sustainable basis?
So I'm going to answer it in a long-winded and apologize.
The judge warned you, eh? Yeah.
I know. So Judge, I'm an ex-auditor. I would say it's about 70%. But the key with the 70% is making sure that it is the right teams that are at 70%. So the right department that need to be capacitated. It's actually, so let's make an example. There's no point of reaching 70% when it's more administrative staff that are making sure that 70%. So the core business of the PIC is quite critical that 70% is actually those warm bodies.
And then another general question, but following from yesterday and all that. Just in terms of the people who came here and said they were victimized, all right? And it's part of our terms of reference, I think 1.10 or somewhere there. And I know you have to give your own version of events and all that. But what's your general feeling? I mean, do you feel, I mean, you are a director and, you know, CFO, acting CE. Do you believe that these people have got some substance in their allegations? I mean, what's your general feeling about this whole thing about victimization?
I'll answer it the best way as I could.
Particularly those who didn't implicate you. Maybe let's...
I can't even remember who didn't.
Okay, all right, okay.
So the truth of the matter is the incentive has been a bone of contention at the PIC. And it's been a big, if you pick up in any climate study of any entity, remuneration is always there, communication is always there. So a lot of the people, and just saying, a lot of the guys who are still employees at the PIC, excluding the ones that relating to IO, came in here regarding their, my views, came in regarding incentive, their remuneration and stuff. So that's a huge contention, and recent changes in the manner that we implement the remuneration policy incentive has actually caused unhappiness within the PIC. So if I recall, Mr. Mervyn Miller came here to say, you know, we were due to be paid an LTI as execs in December, it's not being paid. So, and I guess if you look at how in my view, what came about to the union being established at the PIC comes from that there's a lot of unhappiness in the process, in that, you know, we now no longer pay incentives like in August or end of July after the financials are approved. We now wait until September.
You
mentioned, Mr. Sorry, Advocate?
No, please continue.
Okay, if you're going on to something else, Commissioner? Yeah, that's right. It's just on the question of Mr. Muller's testimony, and you've just mentioned him. In his testimony, he says that in August 2017, most PIC staff were issued with letters stating they were regraded and received significant increases. Yesterday, I asked you whether there was anything in relation to the cost structure that was affected, and you said no. Mr. Muller goes on to state that only a select few, including Mr. Polwane and Matshepo More, were allowed to be involved in the determination of staff grading. He would not sign the letters affecting his staff, and ultimately Mr. Polwane signed off on the letters because he was unhappy with what was happening. He then goes on to state that shortly after the regrading payments of staff in August 2017, and I'm quoting from him, we were told that all appointments of new staff members would be frozen as the regrading shortfall in budget would have to be sorted out first. The freeze was lifted in March 2018. But in August 2018, salaries were again adjusted and not discussed with EXCO, and the principles applied were not disclosed. the point I'm asking here is he says that they were advised that the budget would have to be sorted out first. Yesterday you said there was no implications for the budget. What is correct?
And before she answers, Mr. Commissioner, through you, to add to that, that's what I was going to
Sorry.
ask, is that Mr. Miller also testified till this day you refused to share the implementation of this model with any of the EXCO members.
So in referring to budget implications, so let me to elaborate what the freeze was just about everybody reorganize your priorities. So it was not a freeze because of financial constraints, but it was like reorganize your priorities. Hence, yesterday I highlighted that if you refer to a sustainability target and compare it to what the budgeted amount is that we've never reached the 40% of management fees. We're really about 25 to 30. So the freeze was not due to budget constraints. The freeze was in relation to the fact that the request for every executive head to go back and review and identify the critical positions so that it's not about just filling up vacancies, but that you're cognizant that we're filling up at the right areas. Then regarding...
Sorry, before you move on that, because he's very specifically saying that this was for the budget to be sorted out. So clearly in your EXCO there are different interpretations. Was this clearly set out to your EXCO that they were fully involved in these discussions, in this reorganization, in terms of what their responsibilities were? Because he's very clearly stated that he was excluded. So which of you is correct?
So
Sorry, can I again add to that? His evidence was also that no EXCO member was involved in the regrading process.
So if you recall, so I can't explain his interpretation, but management accounts are presented to EXCO every month, which we highlight availability. He was able to recruit after he'd identified.
That's not what the question is. The question is whether they were involved in the decisions about their own staff with regard to regrading and positions, and whether they were included in your examination, assessment, and decisions on it.
So I was coming to that, so it's providing an explanation. So they are involved. And if you recall in his statement, he even highlighted that they'd had a couple of moderating committees to decide the principles regarding the positions and that what the regrading process is. And my understanding that has been subsequently also been completed in the new financial year. The question regarding the model resides in HR. It does not reside inside my office. So, and I highlighted yesterday that the executive head of HR, being Mr. Chris Polwani, has permitted people who need to know to go have access because he's got a remuneration specialist in his department. So the idea that I have refused for him to have, I can't refuse a model that does not reside within my team.
I don't think that's correct. I mean, you're the CFO and HR reports to you. So the question is not whether the model resides with you, it's what authority you have about a question that has been raised within your EXCO. You do have authority to say, let's resolve this problem. Surely. You were also acting CEO on a number of occasions. Surely you've got authority.
So hence why one of the other issues, and Mr. Polwani highlighted that they allowed access to everybody, and they're detailed to make sure that everyone has access to the model. Hence, I'm reiterating the fact that as much as Mr. Polwani reports to myself, the model resides in HR, and everybody. I know for a fact that Mr. Muller is one of the people who went to Mr. Polwani's office to inspect the model.
Yeah, can I just continue with my question, the other question? Just in terms of salary increases and bonuses, many people have come in and said the process is very flawed, and when people are favored by the CEO and the CFO, people get good increases. If you are in trouble with the top two, you get, less increases or no bonuses and all that. Do you think that what prevails at the PIC? What's your view, general view on that?
My general view is, I think it's been put before this commission that the critical input in terms of your allocation to incentive is actually your balanced scorecard rating. The balanced scorecard rating is deliberated inside the moderating committee. the entire EXCO members are actually members of the moderating, except the CEO. And the CEO is actually not involved. The first time he gets involved is when there's an appeal. So when an employee is appealing the balanced scorecard rating. So deliberation happened, each manager presents in the moderating committee. I wasn't, last year's moderating committee I was not part of, and I think this year, because due to my suspension, I'll also not be part of. But they put together principles, and each manager comes and presents. So if you're going to say someone doesn't like you or something, it has to be, it's inside the balance scorecard. So it's got nothing to do with what the CEO or the CFO could, because it's what is presented by your line manager to the moderating committee. And what the moderating committee does is to also ensure that principles are consistently applied across the business.
So there is no pressure about changing the balance scorecard after the meeting, or, you know, people feeling pressure that they cannot argue with the top two or something like that?
So
What I'm saying, are you saying everything is fine? I mean, the stuff about salaries and the balance scorecard, everything is fine, it works well?
So I won't say everything fine, and you know, I think even prior people, HR that came before me highlighted that there still needs to be improvement in the, first of all, in the creation of the balance scorecard. There needs to be improvement and more in communication, because what then happens if at the moderating committee there's a principle that's not consistently applied, they will ask the line manager to go review it. So now that's where the point of communication becomes quite critical, because then you expect the line manager to communicate clearly when they provide feedback, to say this is what transpired at the moderating committee and what the principal, to provide clear feedback that what happened. So that's why I'm saying the CEO, I'm just one of the members of the moderating committee. The CEO only gets involved when there's now an appeal. And the process of appeal is that an employee will write an appeal and motivate and provide supporting documentation, and that will sit with the CEO for consideration.
So are you saying things are not fine, or are they fine, or some modification?
I'm going to be technical and say they're in the 60. They're not ideally where they should be, because there needs to be more rigorous process regarding the input of the BSC, so that there's less. And I know that with HR we've embarked more on training on how to complete a balance scorecard, training on how frequent feedback is given, and training. So we had started the whole embark process in terms of what needs to happen. The further thing we have done is that we're starting, like you see, EXCO, a lot of EXCO are having coaches, so that we have the ability to help with leadership, with management, to learning of management, more courses on it, to make sure that we improve the soft side.
Just on that, you say EXCO is, all have coaches. Does that apply to you and Dr. Machilo as well, or not?
I can't recall, I can't speak for Dr. Machilo, I'm not sure, but I have one. So I'd started having a coach.
When did you start?
So I had one previously about 4 years ago, and then I can't remember what HR did, they stopped, and then I've got another one which I think I've had for now, 6-7 months?
What I fail to understand, following up on the questions asked by the Commission, is that one of the biggest bones of contention in this organization is salaries and incentives. Why is this policy not made readily available to EXCO members? Why is the implementation thereof not properly explained to everybody? Why is it necessary for an EXCO member to go to the executive head HR to have a look at the policy?
The policy, it resides on the intranet. It's not a secret document. It resides on the intranet. It's sitting on the intranet of the PIC. And if I recall, even about a few years ago, we actually disclosed it in our financial statement. It was one of the annexures inside our financial statement. The policy that is actually currently applicable was a recommendation from EXCO to the HRC, ultimately to the board. So it's not a secret that. And then last year, if not year before, HR had 4 workshops to even reiterate what the policy means, to provide further explanation of what does it mean with the pool. So it's not a secret discussion that happens. So what EXCO will go to HR for is actually the entire model, but the model is there for EXCO to inspect. So if you recall, Mr. Polani, when he indicated he said, after the balance scorecard are actually moderated, each executive head, they sign off on that sheet to say this is what they agree, and that information is just inputted into the model as an administration process.
Final question from me for now. Mr. Polani sort of reports to you. When he was taking people through disciplinary actions and all, did he report to you? Did you sign off on those things? How does the process work?
So, if you recall, Commissioner, yesterday I highlighted that some of us are specialists and we have a cross-functional role. So he doesn't report to me on discipline because he's carrying out what a line manager has entered. So he doesn't come and say, he doesn't seek permission from me because it's the delegation of authority that is awarded to them. So a line manager would say, this is, so if you take the Mr. Shields disciplinary. So it was the line manager, so there'll be the interaction with HR. So it's not my involvement. So my involvement comes in when we are reporting to HRC about the employee relations.
And then does he tell the CEO or you or somebody else, or he can just do it on his own, the whole action, disciplinary action?
So, and I'll give an example. So with Mr. Schill, the delegation of authority will stipulate. So we'll stipulate when you have a suspension at a certain grade, who has the authority. So in certain levels, the authority to put someone on a precautionary suspension resides with the CEO. So in that sense, he'll need to provide a motivation to the CEO while they're placing somebody on a precautionary suspension. Then you got the place where it's just the disciplinary outcome comes with dismissal. So he'll need to come, and I think the signature of that is also the CEO, so he'll need to provide feedback and a whole report to say, yeah, so I'll make Mr. Shill's case in point. He needed to provide feedback to me because the delegation of authority stipulate that I was the one at the time who can sign off on the outcome of the disciplinary hearing.
Okay, thank you. Thanks.
Whilst we are still there, excuse me, in Ms. Manier's settlement amount, was your department involved in those negotiations?
No, sir. So finance would not be, we were not involved in the negotiation of the amount. So the agreement took place at the hearing. And if my understanding is that Mr. Polani discussed with the then CEO to come to agreement with the agreement that was reached.
Did you sign off on the payment?
So I didn't sign off on the agreement. I signed off on
payment.
No, if you recall, that took place around May, and I'd already highlighted that I wasn't around during that time. But I'm sure that not knowing the details, the acting CFO could have signed.
Thank you.
Thank you, Commissioner. Taking into consideration what you highlighted to me yesterday, and I've tried to reflect that I need to adhere to that I'm not long-winded. Can I just maybe ask, in terms of IO, that the Commission allows me to read, and then after that, because in preparation of my statement as relates to IO, I tried to look at all the questions and tried to people who have appeared before the Commission and tried to address them. If you could just permit me, so that I also don't go long-winded in terms of me answering questions.
What's your request?
So I'm just requesting that
go
through the statement, then pose questions, then, if that's permissible.
See, it might be problematic in the sense that a person like me, for instance, at my age, I'll think about something that I want to ask. If I have to wait until the end, I will have lost it.
So, through Commission, so I'll take the questions, because I do think some parts of the statement respond to a question, because I try by all means to follow everything that has happened within the Commission as it relates to this and my involvement. So I'll take the questions.
We have
Either we
covered-
ask
yeah,
questions
yeah.
and you answer, or we take them at the end.
Sorry?
Either we ask a question and you answer at the time. Or we take it at the end and you read the statement in full. But we can't take a question and you not answer.
If you recall, Commissioner, I proposed that you ask the
No,
question
I understand
at the end.
exactly what you're saying, and I'm saying to you that it is one or the other, it is not both.
So
we
I'd
can-
asked for number 2, and I was just taking into cognizance what the chairman was highlighting.
I know what you're saying, right? And I'm saying to you that, and to my colleagues, that it should be either you read the statement and then we go back to the beginning of the statement and we go through with any questions that we've got. Or we pose questions. It's not acceptable to me that we pose a question, you write it down and we come back to it. That's not acceptable.
Can I add, I mean, my problem is that there are parts which have been dealt with here, so I wouldn't really want to hear them again too, so I've got a different problem, so allowing you to read through things I've seen so many times, I mean, that's another story for me.
What is your problem with us asking questions
No, so,
as you go along?
I've got no issues asking questions. It's going on. I was just highlighting that in the manner I've prepared it is to try address the issues, because I think there's also certain information that's been before this commission that I want to provide clarification on. But let's try it, Chair, and then I'll start reading. Thank you.
Sorry, before you do, Advocate Libba, can we ask you for some guidance
Yes.
on this? If we looked at clause 6.7, which is the process by which decisions are taken, we've had that presented a number of times to this commission, and is that something that we need to take as read and given?
Yes, thank you.
And
Mr.
we do not have to have that read into the text? If my
Thank you,
colleagues
that is
agree?
correct.
Happy with that? Yeah, I'm happy with that.
We're happy with that, but let's hear what the witness herself
So,
would like to
Chair,
say.
through you, Commissioner. So from 6.7.5, actually no witness that has come before. So every witness that has come before the commission, when they referred to process, they ended at the point of approval. They never went beyond what happened at until the point of disbursement. Hence why, if you refer to my 6.7.5, I'm not taking through to the process of getting to the disbursement memo and the releasing of the funds. So I don't mind, I can skip certain sections, but the other part, it is my belief that they've never been presented before this commission.
Yeah, I think we had someone from investment operations who was the head who actually gave us some parts about disbursements and, post-approval.
So you had Silo and
Silo Nkwan, I think.
So yeah, but
Silo Nkwan.
he predominantly concentrated on unlisted.
My view
Oh,
is, sorry,
okay,
colleagues,
okay.
if
Yeah.
the witness feels that that would add value that we have not heard before, I think she should read it.
So do you want to go through the whole thing?
If I can please if I can kindly ask for the commission to allow me. I don't want to say I want to read faster, but areas which I think regarding the approval process, I'll try to skip.
I don't think it's going to be easy.
Yeah.
My final word is go through your statement.
Okay, thank you, Commissioner. My understanding is that I've been requested to make a statement regarding the IA transaction because a number of PIC employees who have appeared before the Commission made various statements relating to the process that was followed and the role that I played in relation to the IA transaction. I reiterate that my statement is confined to the information that is within my personal knowledge and/or that relates to me in my capacity as the CFO and a member of the Portfolio Management Committee listed, PMC. At the outset, I wish to point out that a number of investigations have been conducted in respect to the IA transaction, and that allegations were leveled against me by various people during such investigations. As pointed out already, some of these allegations were made before the Commission. It is not my intention to deal with each and every statement and/or allegation made in relation to the IA transaction by the various witnesses that have appeared before the Commission. Rather, I wish to address the following specific themes that arise from the testimony of the various witnesses: the disbursement memo of 19 December 2017, the PMC meeting of 20 December 2017 with specific reference to the ratification of the undertaking of the due diligence process, the investment case for the IA transaction, the outcome from assurance providers, the conditions imposed by the committee, and allegations related to rubber stamping of the irrevocable undertaking, and the payment of IO transaction funds. Should the Commission require I address specific issues relating to the IO transaction not covered in the statement, I would be amenable to prepare a supplementary statement dealing with such specific issues. I wish to point out that I've made an effort to cover topics and/or questions that I believe so far been raised by the Commission in relation to the IO transaction, to the extent that same relate to me. Before I deal with the above themes, I wish to outline the process followed by the PIC when considering transactions of a similar nature as the IO transaction, i.e. domestic initial public offerings, which are referred to as IPO or private placement, including the role played by the Finance Department. A potential investment is referred to the deal team, investment professional, i.e. investment professionals, for an initial high-level assessment. Once the initial high-level assessment has been completed, the deal team presents the submission to the PMC, which we refer to PMC1. Once considered and approved by the PMC, the transaction is referred back to the deal team for commencement of a due diligence process.
Sorry, can you read a little slowly? This has to be transcribed,
Okay.
and we need to follow what you're saying. It's not just rote.
Okay.
Please just go through it properly.
Perfect. The deal team will interact with legal, risk, and environmental, social, and governance, referred to as ESG, teams to address specific areas of the due diligence process. Once completed, the due diligence report with key findings and conclusions will be presented to PMC, i.e. PMC2, and where applicable, the delegated committee of the board, i.e. the investment committee, which is referred to as IC, in accordance with the delegation of authority for listed investments for consideration. The relevant committee is the final approval authority of the transaction, as informed by the due diligence process and report. The Office of a Company Secretary of the PIC prepares
Okay,
them.
when you say the relevant committee, you mean the IC?
So IC, so if there's a need, which is driven by the delegation of authority, could go all the way to the board. So it's based on the delegation of the delegations of authority.
But here, you're talking about the IC.
So when
Where you say relevant authority, or could it be any one of those?
So as it relates to listed, so you have PMC, investment committee, and the board. So because I'm just outlining the process, I'm just saying relevant, so it's not directly applicable to the IO transaction. The Office of the Company Secretary of the PIC prepares the minutes of the meeting and the resolution of the committee that considered the transaction with the assistance of the deal team and the legal team, which provide input on technical aspects thereof. The chair of the considering committee signs the minutes and the resolution of the committee. Once the considering committee duly approves the transaction, the deal team, where applicable, with the support of legal team, is responsible for implementing the transaction, including, where applicable, ensuring that all conditions are fulfilled. As an example, I attach here to a letter that was prepared by a member of the deal team addressed to AEP Energy Africa Limited, amongst others, advising of the conditions imposed by the approving committee that need to be complied with in relation to the proposed transaction, marked Annexure MM25. I further attach here to an extract of the standard operating procedure for the listed investment, which is the corporate actions, IPOs, rights issue, book build, etc., that reflects the process as outlined, marked Annexure MM26. Once the deal team has satisfied itself that the process in relation to the resolution of the considering committee have been complied with and the transaction is ready for payment, they will then load the investment onto the Charles River system, which is the listed trade system. Once the Charles River system generates an equity trade ticket, the deal team sends such ticket and the resolution or certified extract of the minutes of the meeting of the considering committee to the finance team as part of the instruction to settle the trade. By the time the deal team sends and generates a trade ticket, they would have already engaged the fixed income team, which is the team that is responsible for the treasury function, to check availability of funds. This is so because, as a norm, the organization would not keep high cash reserves as the cash are invested at all times. In circumstances where the transaction exceeds the amount available in the bank accounts, the funds will be procured through, among other things, the liquidation of instruments in order to avail the necessary funds at the settlement date. This is aligned with the client mandate, which stipulates how much in the portfolio can be held as cash.
I'm not sure that you have reduced speed.
Oh, sorry. Okay. I think Advocate Love is forgetting to just give me the hand. Okay, I'm going to try. Upon receipt of the trade ticket, the finance team will then make necessary arrangements to ensure that all is in order for the transaction to settle at settlement date. Within the finance team, the settlement of the trade is loaded on the bank system by any one of the loaders set out in Part 4 of Section E of the Delegation of Authority listed, and the funds are released by any two of the finance employees set out in Part 3 of Section E of the Delegation of Authority of listed. I attach here
Would those reside under you in your
in finance, so
department?
they sit in finance, the releases. I attach here too the delegation of authority listed, marked annexure MM27. I wish to point out that the finance team, including the CFO, is not involved in the initial processes leading to the approval of a transaction by the considering committee. The only limited involvement of the finance team in these initial processes is with regards to the CFO being a member of the PMC and a representative from finance being an official that has a standing invitation to the meetings of the PMC. In this regard, I refer to Section 6.2.1 of the Terms of Reference of the PMC, which I attach here to, marked as Annexure MM28. I now proceed to address the respective themes. The 19th December 2017 disbursement memo, which I shall refer as disbursement memo. At the outset, I wish to highlight to the Commission, in the strongest possible terms, the conduct of the compiler seeking to conceal the existence of the irrevocable undertaking and/or the lack of the required approval under the pretense of a disbursement memo. As is clear from the statement of the compiler, Mr. Siani, he was aware of and deliberately concealed the non-compliance and misrepresented fraudulently what should have been an approval or a condonement memo as a disbursement memo. It is incontrovertible that this deliberate act was intended to mislead the signatories who were not privy to the discussion referred to in Ms. Adams' statement, which I've referred as, if you refer to Ms. Adams' statement, page 4 to 5, into signing the proprietary disbursement memo.
He says he was never asked about it in that PMC meeting.
So we get into that, Richard, but the 20. So now I'm still dealing, Commissioner, with the 19th, which is the information that was disclosed on the disbursement memo.
It is also not in dispute that the irrevocable undertaking was part of the email sent also to you before the meeting of the 20th of December.
So I come to that later on when I deal with the irrevocable, because the critical things regarding IO transaction, what transpired, is actually timing. So I'll come in, you'll see when I discussed, and hence why I've specifically made the 19th, the 20th, giving the events, because it's specifically written to give an account of the timing. On 19 December 20...
No, but can you tell me what happened on the 19th
So
that causes you to say that he didn't disclose?
So on the 19th, which you'll see when I go through, is what was presented before me was the disbursement memo and what the details in the disbursement memo indicated. So I go through in my statement and highlight. On 19 December 2017, I arrived at the office after lunchtime. In this regard, I refer to the email correspondence reflecting the discussion amongst the relevant employees regarding the signing of the disbursement memo, attached here to, marked Annexure MM29. Upon arrival at the office, I was handed the disbursement memo by my personal assistant, who indicated that she was informed that it was urgent that I consider and countersign the disbursement memo. I attach here too a copy of the disbursement memo as Annexure MM30. The following contents of the disbursement memo are noteworthy. The purpose of the disbursement memo was to request Dr. Dan Majila, in his capacity as the Chief Executive Officer and authorized signatory of the Public Investment Corporation, SOC Limited, PIC, approve payment of, 4 billion in respective of proposed acquisitions by the PIC of 99 million, so I'm not reading the numbers, ordinary shares of IO Technology Solutions and transaction costs. The PMC would ratify the PIC's acquisitions of the IO shares on behalf of the Government Employee Pension Fund, GPF, at its next meeting. That between the 16 November 2017 and 14 December 2017, a due diligence on IO was conducted. That the due diligence process concluded that the IO transaction, based on management's forecast, appeared to be a reasonably attractive catalytic investment to stimulate significant transformation in the ICT sector. And the memorandum recommended that the CEO approve the payment of the subscription price. When handed to me, I noticed that the disbursement memo had already been signed by Mr. Victor Siani, the Assistant Portfolio Manager of Listed Equity, Khanewe Adams, Acting General Manager of Listed Equity, Leon Smith on behalf of Fidelis Madavu as the Executive Head of Listed Investment, Winnie Sichedi on behalf of NSCI Executive Head Legal, Brian Mavuga, General Manager Finance. In addition, the disbursement memo had been approved and signed by Dr. Dan Majida, which is Dr. Dan, and that my signature was the only one outstanding.
Was there anything wrong with that other people signed before you?
So it is. So each of us provide a certain assurance level to the final approver. So people signing before me, they play a certain role. So if you go to the memo and reflect, and you see what they sign, so you'll see that Winifred would have signed conditions precedent had been made. Mr. Brian Mavuka would have signed that funds are available, and then Mr. Leon Smith would have signed that he recommend. Ms. Khanewe would sign that she's reviewed the memo. So each person is an advisor. So what you could argue that it's that it was taken to the approver prior to my signature, because I'm also one of the advisors in the memo.
Yes, I note in the memo you're the last one to sign.
But
Or your name is last. In the
no, it's
list.
not last. My
Not
name
last.
is second last.
There's-
So
there's-
I'm one of the advisors who provides advice in terms of funds available. Okay. So I'm moving to 6.8.6. I signed a disbursement memo for the sole purpose of confirming that the requisite funds are available. I wish to bring to the Commission's attention that when I appended my signature, I crossed out the words approval or not approval, which appeared above my signature, in order to make it clear that the purpose of my signature was not to approve nor disapprove the disbursement. This is so because such powers does not lie with me. Hence, the approval was requested from the CEO. Thus, how we at the PIC have understood and have applied the requirements of Section E of the Delegation of Authority of Listed is that the CFO signs for the purposes of confirming availability of funds at point of settlement, and the CEO signs for the purpose of approving this disbursement. In this regard, and solely for the purpose of highlighting the practice that is followed within the PIC in effecting payments on transaction involving listed investment, I attach here too a copy of a disbursement memorandum in relation to Cipla IPO marked Annexure MM31, which was executed during the time when I was on maternity leave in 2018. It is to be observed that in respect of the section bearing my name, Mr. Brian Mavuka, in his capacity as acting CFO at the time, also crossed out the words approve or not approve. Further, this fact is confirmed by Mr. Sunil Vasaki in his statement dated the 14th of March 2019 under paragraph 10.5, the extract of which is attached here too marked as Annexure MM32. I am aware that questions have been raised as to why I confirmed that funds were available on the 19th December 2017, whilst Dr. Dan had notified the JSE that funds would only be available on the 22nd December 2017. I refer to the process outlined in paragraphs 6.7.8 above relating to the procurement of funds. I wish to emphasize that in the ordinary course of business, there are limited funds idling in the bank account. This does not necessarily mean that there are no funds available for a particular transaction. Funds need only be available on the date of settlement. I further wish to point out that I only became aware on 12 March 2019 that Dr. Dan wrote to the JSE when this fact was presented to the Commission during Ms. Candace Abrams' testimony. I attach here too the extract of the transcript of Ms. Abrams' testimony marked Annexure MM33. In my view, what Dr. Dan wrote to the JSE with regards to the process of liquidation is not inconsistent with the process of ensuring availability of funds at settlement date as outlined above. In any event, and without detracting from the process I have set out above, even if an assessment of the availability of funds were to be made on the day in which the disbursement memo was signed, as a matter of fact, the main bank account, which we referred to as STD004, had funds in excess of 5 billion on the 19th of December. In this regard, I attach here too an extract of the bank statement reflecting the balance in the main bank account on 19 December 2017, marked Annexure MM34. There is a suggestion that I should have not signed the disbursement memo as the transaction was not duly approved by the PMC at the time of my signature. First and foremost, I wish to reiterate that the main purpose of appending my signature was to confirm availability of funds, something that is unequivocal from the disbursement memo itself. For the purposes of confirming availability of funds, the disbursement memo did not need to have a PMC resolution as supporting documentation. The only document needed to confirm availability of funds was a bank statement. The considering committee resolution, together with the trade ticket, are only required at the point of releasing the funds. I am aware that the Commission has been told that reference to the words "the PMC will ratify at the next meeting" was in relation to the ratification of the fact that the transaction had already been concluded by virtue of the irrevocable undertaking that was executed on the 14th December 2017. This could not have been my understanding at the time of signing the disbursement memo, as I was not aware at all about the existence of the irrevocable undertaking. It is common cause that the existence of the irrevocable undertaking was not disclosed in the disbursement memo. I deal with this issue in detail under paragraph 6.12 below. At the time of signing the disbursement memo, I was laboring under an honest belief that the transaction had already been approved through a round-robin resolution of the PMC. This is so because on the 15th December 2017 at 14:25, the Office of the Company Secretary sent out to the members, including permanent invitees of the PMC, an email requesting them to peruse the documents and indicate whether they are approved or not approved through a round-robin resolution. I attach here too a copy of the email marked Annexure MM35. It is to be observed that one of the attachment is a round-robin resolution of the PMC for the approval of the IO transaction.
I'm sorry to interrupt you. You say in 6814, you were laboring under an honest belief that the transaction had already been approved through a round-robin resolution of the PMC. On what facts did you base that honest belief?
So if you refer to, it coincides, so I highlight in that paragraph that there was a round robin that was sent out on the 15th. Then I highlight that point 2 of the disbursement memo, which I deal with, specifically came and said PMC will ratify. I further deal with it in terms of this statement to highlight, to say what in my interpretation of the word ratification, because it's governed by the terms of reference of the PMC list. So you'll get the answer, the detailed answer, when it comes in to say my interpretation of what part 2 of that memo said was stipulated. So if I continue on 6.8.15.
Can I just understand, were you back from maternity leave by that time? Can you just remind me?
No, I only went on maternity leave on March 2018. This is, this time I was pregnant.
This time.
2017.
December.
All right. Sorry about that. But
Okay.
as a member of the PMC, would you not be required to sign that round robin yourself?
So I come in to say, in terms of reference of the PMC, you only require 75% for a resolution to carry through. So, and I actually also attach an example of one of the round robin where it carried through even if one member had not signed. So the terms of reference stipulate what shall be the process regarding a round robin that you reach 75%, and I later on provide more details in explaining that. Thank you. So
Sorry, just because the question has been answered, because I didn't want to ask, that's not the answer as to why you didn't sign. The question is, did you deliberately not sign because you felt there was a 75% already there? Or was it something, because you simply say you did not sign the round robin. It's not whether there was 75% already signed, therefore I don't need to sign. You're the CFO, you were acting CEO at the time. Why would you have not signed? I mean, was there a reason for it other than saying, well, it's a round robin and you've got enough signatures? Surely as CFO, you have a different weighting in the signing of a round robin in relation to a decision.
So I'll come into it in details a minute. So if you refer to my statement, I refer to that I did not remember the round robin was sent on the 15th, and it was the deliberation that I had not submitted a view, and the lack of submission of my view in terms of the 15th does not prevent a round robin resolution carrying forward. Then just to
I
answer,
understand that it doesn't prevent it going forward, but as a CFO on a significant transaction of 4.3 billion rand done by round robin, surely a decision not to sign is a decision. So I'm asking whether it was a decision or it was something that, oh, well, if there's enough I mean, I'm trying to understand why there was no signature.
So I actually provide explanation inside my statement to say, because I had not, remember, you have a round robin and they say consider the document. I had not considered the document. And I highlight in my statement that even if I'm the CFO, in terms of proceedings, in terms of the round robin resolution, I carry no bigger power.
About bigger power, I'm not asking whether you carry a bigger power. I'm asking why, if you felt that you could not sign because you haven't read the document, did you put a note on the round robin that I'm not signing because I haven't yet considered the document, or did you just leave it blank?
If you refer to the email that was sent out on 1425 with the Office of a Company Secretary, they actually highlighted that they actually require a response in email, and then that documents will follow through later on. So I hadn't responded to the email. So I think it's 6.8.15. Have I read that? Sorry.
That's where you are now.
Yes, 6.8.15. I did not sign the round robin. However, in light of the fact that the disbursement memo indicated that the PMC would ratify the acquisition of the ordinary shares of IO at its next meeting, my understanding was that the round robin resolution was duly passed through the requisite majority and that it needed to be ratified as required in terms of the terms of reference of PMC, that a round robin resolution must be confirmed in the next meeting after it is passed. In this regard, I refer to paragraph 8.2.4 of the terms of reference of the PMC, which is annexure MM28. In order to further illustrate the point, I attach here too, as an example, an agenda in terms of which a round robin was to be ratified at that meeting marked annexure MM36. I further attach a copy of the said round robin, which was not signed by all members of the PMC, marked annexure MM37. In this regard, I wish to point out that if I was aware of the existence of the irrevocable, I would not have inserted conditions next to my signature to the effect that just inquire if risk should be part of this memo and ESG to recommend that all in order. Thus, any risk assessment at that stage would have been obsolete. Following my signing of the disbursement memo, and in an attempt to follow up on the conditions I made when appending my signature, I contacted the then executive head of risk, Mr. Paul Magula, to establish risk position on the IO transaction. Mr. Magula alerted alerted me that the requisite 75% voting threshold for the IO round-robin resolution was not achieved, i.e. there was no PMC approval for the IO transaction. I then contacted the General Manager of Finance, Mr. Brian Mavuga, informing him not to do anything further in relation to the processing of the disbursement memo until the transaction is duly approved. I further contacted Dr. Dan Machila, informing him of the instruction that I'd given to the finance team, and that in the circumstances, this transaction can only be implemented if due process is followed, i.e. if PMC approval is obtained. We then agreed to convene a PMC meeting in light of the applicable time constraints of impending listing of IO.
Can you please put a date
So,
to that discussion with Dr. Machila?
So if I recall, I think that discussion happened on I think it was at the 20th. So I have to just look at my phone record to say it's between late on because the decision to inform the General Manager of Finance was late on the 19th. I'll come back, I'll look for my phone records. I think yeah, it was the 20th. Upon realizing that there was a step in the process that should have been followed prior to Dr. Machila approving the processing of the funds, I then took it upon myself to ensure that there was compliance with the PIC processes. The fact that I was instrumental in ensuring that no payment was made without the transaction being presented and approved by PMC is clear for the correspondence leading to the meeting on the 20th December 2017. As an example, I attach here to email correspondence of the morning of 20 December 2017, marked MM38. Accordingly, even if it were to be assumed that I was wrong in signing the disbursement memo without having first seen the PMC approval, something which I deny, I immediately took remedial steps to ensure that such error was corrected prior to the disbursement memo being given to effect. Thus, that alleged error has no legal or financial consequence as it was immediately rectified. There were questions as to why a PMC meeting was convened on an urgent basis. First and foremost, the PMC Terms of Reference makes provision for the convening of a special PMC meetings, and therefore any suggestion that it was irregular is misplaced. It is a normal commercial practice that where commercial consideration dictate or make it necessary that an urgent meeting is convened, such meeting should be convened. In the case of the IO transaction, we considered the fact that the listing had to occur as scheduled due to the fact that the British Telecom South Africa, BTSA, transaction was already at an advanced stage, which was the main driver for the decision to consider the IO transaction. This issue was in fact deliberated at length at the PMC meeting of 20 December. I refer to paragraph 6.11.4 below, which deals with the investment case for the IO transaction. Further, there were questions around the fact that some of the members of the PMC participated in the acting capacity. I wish to point out that in terms of paragraph 1.18 of the PMC Terms of Reference, a member of the PMC includes someone who has been duly appointed in terms of the delegation of authority to act on behalf of a member of the PMC. It is common cause that such acting member has the same powers and responsibility as the delegated member to deal with the PMC of the 20th December 2017. On the morning of 20 December 2017, at the instruction of the CEO, the Office of the Company Secretary sent an email to the members of the PMC requesting they indicate their availability for PMC meeting at 1300 hours or the following day at 0900 hours. I attach here too a copy of this email marked Annexure MM39. Later in the morning, on the 20th of December, I requested Mr. Mavuga to inquire with the Office of the Company Secretary whether there will be a quorum for the proposed meeting at 1300 hours. The Office of the Company Secretary confirmed that there would be a quorum for the meeting. The purpose of the meeting was twofold, namely, to consider whether to ratify a decision to undertake a due diligence without PMC1 approval, and to consider whether to approve or not approve the IO transaction based on, among others, the appraisal report, including the outcomes of the due diligence, which is PMC2. I pause to highlight that evidence was laid before the Commission by Mr. Siani that there was ambiguity about, amongst others, the purpose of the meeting and the reason why it was called. I attach here too extract of Mr. Siani's relevant testimony before the Commission marked Annexure MM40. I confirm that the members were notified by the Office of the Company Secretary of the purpose of the meeting. Further, at the start of the meeting, I inquired whether the members were in possession of the agenda. The Office of the Company Secretary confirmed that the documents were emailed to the members prior to the start of the meeting. I am certain that the recordings of the meeting will reflect this fact. Ratification of PMC 1, due diligence. The PMC took a decision to ratify the undertaking of the due diligence without prior approval of the PMC. I attach here too a copy of the minutes of the meeting marked Annexure MM41. In taking a decision to ratify the due diligence process, the committee took into account the fact that the due diligence work had already been done and that there were reports that had already been generated and submitted as part of the appraisal report. I noted that there were questions raised during the testimony of Mr. Lufuno Namagovani, to the effect that deviations do not occur at the PIC. I wish to put it on record that at times deviations do occur when situations necessitate such. For example, in the ADCON transaction, management approached the IC to assess their appetite to consider the proposal. In response to management's request, the IC approved the transaction subject to the successful due diligence outcome. In the event that the outcome of the due diligence was negative, the transaction will need to be referred back to the IC for reconsideration. I attach an extract of the minutes of the IC meeting of 4 December 2018, marked Annexure MM42. I further noted Mr. Siani made a statement before the Commission to the effect that, in essence, there was an unreasonably short time available for the due diligence and that he only started undertaking the due diligence from the 24th of November 2017. I wish to point out that this is not consistent with the information that was disclosed in the disbursement memo and the information that served before the committee. In both these documents, which were compiled by Mr. Siani, a due diligence on IO was conducted from the 16th November 2017 to 14 December 2017. I further wish to point out that during the meeting, in justifying why the due diligence was commenced with prior approval to the PMC approval, Mr. Siani indicated that he had to commence with the due diligence early in order to afford himself enough time to timelessly complete the due diligence. He specifically did not mention that he needed more time to do any further investigation. In this regard, I am certain that the recordings of the proceedings of the meeting and the relevant documentation will reflect this point. I do, however, wish to put out that risk, legal, indicated at the point of completing the due diligence, they were in possession of the draft pre-listing statement, which is referred to as the PLS, and that they had since received the final PLS as well as the signed financial statement. The deal team and risk further indicated that they had reviewed the signed financial statement and they were comfortable with them. It was on this basis that PMC decided to include a condition to the effect that they should update their reports to factor in the information that has been subsequently received. Hence, reference was made to them having to complete the due diligence. I am certain that the recordings of the proceedings of the meeting and the relevant documentation will reflect this point. I further noted Mr. Siani in his statement mentions that during the preparation of the SCOPA report, he informed management that he did not request the PMC meeting to approve a due diligence into the I transaction, as he did not believe that the I transaction had investment merit, and he therefore initially shelved working on it. I wish to point out that this is clearly inconsistent with his statement that, open quotation, as a result of the very short time frame, at least 70% shorter than usual, to conduct the IO process, I believed it was in the best interest of our clients and the PIC for all relevant teams to immediately commence research into IO. As a result, on the 27th of November 2017 and 13 November 2017, I made a professional judgment call and requested for ESG, risk and legal teams to allocate team members to assist on the IPO. The intention of my request was to quickly alert these teams to the fact that due diligence would be required due to the fact that there was extreme time pressure to conduct the IO process, close quotations. I further wish to point out that it is incorrect that Mr. Siani informed management that he did not support the IO transaction. In fact, he was the compiler of the documentation that served before both the IC and SCOPA, all of which indicated that the deal team, which he was part of, supported the IO transaction. In this regard, it should be noted that I was on maternity leave when the documentation was presented before the IC during May 2018. Accordingly, Mr. Siani's statement that I tried to explore a different way of presenting that he did not request for PMC as he did not support the transaction is clearly factually incorrect. If that was the case, I would have pointed him to all these facts that show that he wanted to do a due diligence and he actually supported the transaction. In his statement before the Commission, he indicated all the steps he undertook in order to ensure that the due diligence was carried out, referring to the decision on the IO transaction.
Commissioner, is this a convenient time to take the tea adjournment?
Let's come back at past. We'll adjourn at
Thank you, Mr. Commissioner. Okay, I'm trying to get Lizzie to get you a copy with annexes. You're again welcome.
at the time of considering this transaction, BTSA had already agreed for its CEO to move to IO, coupled with the fact that the share in BTSA was already held by a related party, i.e. African Equity Empowerment Investment, or AEEI, to IO. It appeared inevitable that the transaction would be concluded. Outcome from assurance providers. In terms of all the reports of the assurance provider, risk, legal, and ESG, none of the risk identified in the report suggested that investment was not viable. Further, in relation to the risk identified, the report suggested mitigating measures to address such risk. After consideration of the investment case and the outcome of assurance provider, the committee took a decision to approve the IO transaction, subject to certain conditions which were aimed at addressing, amongst others, the risk identified and ensuring that funds are used in accordance with what was stated in the pre-listing statement. I attach hereto a copy of the resolution of the committee marked Annexure MM45. I further refer to the minutes of the meeting of the committee, which are Annexure MM40. I noted that Mr. Sian in his statement mentions that the risk team raised pertinent concerns relating to IO's transactions such as counterparty exposures, Project Iris, governance and revenue forecasts, among other things, close quotation. I wish to point out that this statement is factually incorrect. In terms of the credit risk report that served before the PMC meeting, which is annexed at MM43C, all these specified elements were all rated medium. Other ones were rated low. None of the risk elements identified in the credit risk report was given a high rating. I further wish to point out that the committee adopted mitigants recommended by the risk team, hence they were included as part of the approval conditions. The conditions imposed by the committee. After deliberations, the PMC imposed the following conditions on the IO transaction: that all funds raised from the pre-listing will be used only for acquisition of growth. This condition was to ensure that the capital was used to fund organic growth and acquisition pipeline. This condition was to further regulate by way of a formal agreement that the PLS that stated the funds were to be used for. That shareholder approval for all acquisitions other than BTSA that are greater than 10% of the market cap is obtained. This condition was to ensure that the shareholders have the say in material transactions and that other acquisitions are aligned with our investment thesis. That a put option be in place to protect the PIC's clients from a share price decline, which would enable the PIC to put the shares to IO. That IO appoints 9 executive directors, majority of whom should be independent, to ensure alignment with good corporate governance. Implementation of a conflict of interest policy to govern any related party transactions, and the performance of a complete due diligence by legal and ESG, i.e. provisions of comfort on the final PLS and the signed financial statement. There were questions raised as to the nature of the conditions, and more specifically, whether there are conditions precedent or not. I agree that the word used in the resolution in a minute is not explicit on whether a particular condition is a condition precedent or a post-transaction condition. However, from the deliberations of the committee, it was clear which condition had to be fulfilled prior to the funds flowing and which condition had to be fulfilled thereafter. In this regard, I request the Commission to obtain the recordings of the proceedings of the meeting. I am certain that the Commission would pick up that, for example, condition relating to the put option was a condition precedent. It was specifically resolved that should I not agree to conclude a put option, the funds will not flow. There were questions also raised that the put option was inserted because the committee did not have confidence in the price. In dealing with this, it is necessary to outline the work done which the deal team presented to the committee, which resulted in them concluding that the price was reasonable. A reverse test was done on the price, which came out with a PE multiple of 16. And when compared to other industry players of a similar profile, the PE multiple was considered to be reasonable. I recall specifically inquiring if a sensitivity analysis was performed on the revenue growth, and the deal team confirmed that they conducted the necessary tests. In this regard, I refer to the following conclusion that the deal team arrived at as per the appraisal report, which is annexed to MM43B. Open quotation. At a forward PE of 6 times on management's earnings estimate, the I transactions appears to be a reasonably attractive catalytic investment to stimulate significant transformation in the ICT sector. Close quotation. I am certain that the recordings reflect all the deliberations that took place in relation to the deal team's conclusion that the price was reasonable. The committee then resolved that in order to ensure that there is protection in the event that management doesn't implement the said pipeline, which would have a negative impact on the earnings and thus result in a share price decline, the put option was considered a viable downside protection. In the circumstances, a determination of whether the decision that was taken by the PMC on 20 December was right or not should be based on the information that served before the committee. Rubber stamping of the irrevocable undertaking. There were allegations that the purpose of the 20 December meeting was to rubber stamp the transaction, as the irrevocable undertaking had already been concluded on the 14 December 2017. This is factually incorrect and is not borne out of by the facts presented before the Commission. Neither the disbursement memo, the attachments included in the emails of 15 December 2017 from the Office of the Company Secretary, nor any report that served before PMC of 20 December 2017, which are annexed MM43B to MM43E, disclosed that the irrevocable undertaking had already been concluded. Furthermore, of those in attendance at the meeting who were aware of the existence of the irrevocable undertaking did not disclose that it had been signed. I refer to the minutes as well as the recordings of the meeting. The non-disclosure of the irrevocable undertaking is further confirmed by the submission made by the deal team on May 2018 meeting of the PMC, requesting that the PMC notes and ratifies the participation in IO private placement due to the fact that at the meeting of 20 December 2017, the PMC was not notified that on 14 December 2017, an irrevocable undertaking was signed. During the testimony of Mr. Siane on 30 January 2019, a statement was made by the evidence leader on the day to the effect that on the basis of the evidence of the internal auditor, Mr. Machila and I, the most important people at the meeting, were well aware of the existence of the irrevocable undertaking and that it was disingenuous of us to accuse Mr. Siane of having not disclosed that fact at the PMC meeting of 20 December 2017. I refer to an extract of Mr. Siane's relevant testimony, which is annexed to MM40. I also attach here too a copy of the transcript of Mr. Nemakovani, being the internal auditor referred to, for the Commission's ease of reference, marked annexure MM46. It is my view that Mr. Nemakovani did not identify me during his testimony as having known prior to the meeting of the existence of the irrevocable undertaking. Rather, Mr. Nemakovani's testimony was to the effect that the PIC management informed him that the people who are responsible are the Chief Executive Officer, i.e. Dr. Machila, the Executive Head of Listed, and the General Manager of Listed Equities. However, I wish to point out that it came to my attention post the PMC meeting of 20 December 2017 that Mr. Siane's email of 19 December 2017, to which I was copied, requesting the IT department to increase the loading limits of certain employees, had an attachment thereto, as an attachment thereto, signature page of the irrevocable undertaking. I attach here to copies of the email as well as the signature page marked annexure MM47A and MM47B. It's to be observed that the attachment is titled Application Form. At the time of receiving the mail, I did not open the attachment as the email was not addressed to me, and the request to IT was merely an administrative function to grant people with delegated functions access to the system. Further, it should be noted that at the time of the signing of the disbursement memo, which was around 1520, as per email correspondence attached here to, marked as Annexure MM48, which was shortly before this email was circulated, which was around 1552. I was never involved in any substantive deliberations regarding IO transaction with either the deal team or any of the signatories of the irrevocable undertaking. In any event, it should be remembered that the decision to approve the IO transaction was unanimous and reached after extensive and robust deliberations. I further wish to emphasize that none of the reports presented before the meeting recommended that the transaction should not be pursued, and that the committee did not identify any material risks that warranted a decision not to pursue the investment. In the circumstances, I think that there is no factual basis for the allegation that the PMC approval was a rubber stamp. Payment of the IO transaction funds. As already pointed out above, the responsibility to ensure fulfillment of conditions lies primarily with the deal team, where applicable with support of legal. I wish to point out that as the CFO, I only release funds in exceptional circumstances, i.e. emergency, which I believe since being appointed as CFO, I've never released any funds on the bank system. Thus, I did not play any role in the implementation of the condition of the PMC on 20 December 2017, nor did I play any role in the settlement or releasing of funds. Accordingly, the evidence that has been presented before the Commission by Mr. Siani that I released the funds is plainly incorrect. So is the statement that the funds were released the day before, i.e. the 19th of December. The funds were released after the 20th December 2017, following the approval of the PMC. I attach here to extract of Mr. Siani's relevant testimony before the Commission, marked as Annexure MM49. On the contrary, it is Mr. Siano who initiated the payment process shortly after PMC meeting of 20 December 2017. I attach here to relevant correspondence between Mr. Siani and the accountant submitting the necessary documents required to commence with the payment process, marked Annexure MM50. I wish to reiterate that funds are only released by the finance team at the instruction of the deal team. In conclusion, I wish to highlight that I have been labeled and/or depicted as being the kingpin in relation to the processes that unfolded in respect to the IO transaction. In my view, it is clear from the documentation and evidence before the Commission that my role in the IO transaction was limited to confirmation of availability of funds in the disbursement memo, ensuring that there was compliance with PIC processes by facilitating the convening of and participating in the 20 December 2017 PMC meeting. Accordingly, I believe that my involvement in the IO transaction has been grossly exaggerated and misrepresented by those persons who have appeared before the Commission. I'm waiting for the questions, Commissioner.
Thank you. Mr. Commissioner, can I commence with, or would the Commission prefer to commence with questioning?
Sorry, can you repeat that?
Would the Commission prefer me to start with the cross-examination, or would the Commission prefer to start?
You can carry on.
Thank you. Thank you, Mr. Commissioner. Mrs. More, can you please tell the Commission when did you hear for the first time of the AO transaction?
So the first deliberation or like a special interaction regarding the IO transaction was when Mr. Brian Mavuga, the then general manager, on the 19th of December, he called me before I arrived at the office, highlighting that, inquiring if I had given his telephone number to PSG.
I want to make sure you understand the question. Was that the first time that you learned of the PIC investing in AO?
Okay, I think I maybe, so there was, I might be confusing, but I'm going to try. So there was the email of the 15th, and then the first detailed discussion with regarding the IO transaction was the 19th. I'm not sure if I'm answering correctly.
So is it correct then that before the 15th of December 2017, you haven't heard about the PIC going to invest in AO?
Or there being a transaction.
So through Commissioner, so it's a very difficult question to say. It's not necessarily whether it's for the first time, what I'm trying to, and I'm trying to answer as best as I can, the first time that I have deliberations regarding, or involvement regarding the IO was between. So I'm not sure if, like maybe if he clarifies that hearing in the streets or hearing officially inside the PIC.
Let's make it simple. It was a simple question, and I'm going to repeat it. Whether officially or non-officially, when did you hear for the first time that the PIC is going to invest in AO?
Unofficially, I don't know what's unofficial. So, but as I'm saying that now, the emails of the 15th.
I think Council says it doesn't matter where you heard it.
So that's why I'm trying to think. I can't remember of a time that maybe I was sitting somewhere, unless you can provide clarification, because it's about 2 years ago.
No, I think it's quite a simple question, really. When did you hear for the first time about the PIC going to invest in IO? I think that's the question. Was it before the 15th of December? On the 15th of December? Or another date?
So that's what I'm saying. If memory, where it's the email of the 15th of December.
You see, why I'm asking this question is I have with me a delegation of authority that says that strategic investments listed for amounts greater than 3 billion but less than 10 billion must be agreed beforehand by inter alia the CEO and the CFO.
So in answering that question, Chair, so there's a delegation of authority at the PIC, and as it related to listed, that delegation of authority was not actually applied. The practice was not applied. Subsequently to that, you will see that the delegation of authority which was approved, which I've got a copy of for the members, was subsequently annexed. It was amended to remove the involvement of the CFO. So the teams, in terms of, they do not engage with me pre-PMC. So it was the practice that they will never have engaged with me regarding the IO. As much as that was the B under the section of 6.2 of the delegation of authority, that was not the practice. And hence why the delegation was subsequently modified, because the team did not participate in such.
So, just to get it clear on record, this was not complied with.
So that section, the involvement of the CFO, yes, that was not the practice, hence why they've changed the delegation to remove my involvement.
Ms. More, it was not complied with.
Yes, I've confirmed yes.
And secondly, and more important, the CEO of this organization, Dr. Matshepo, did not take you in his confidence to inform you before you signed the disbursement memorandum or at the meeting of the 20th of December that he has already, without consulting or speaking to you, signed an irrevocable transaction with AO.
I confirm he did not take me into his confidence.
This is a gentleman that you've been working with for more than 10 years, and you had, as you explained yesterday, an excellent relationship with.
So, like I highlighted yesterday, I had a professional relationship. It's not about that he tells me everything he does because he's got the delegation. So my relationship with Dr. Dan, it was a professional relationship. He was my boss and I worked with him for 10 years. He had no obligation as my supervisor to tell me everything that he's undertaking.
Don't you think, at least, there was a moral and ethical duty on him as your boss and co-director on the board of the PIC to inform you of a transaction in excess of 4 billion rand?
So it's difficult to answer a question on somebody's morality and what they believe at the time. So like I'm going to highlight in terms of processes at the PIC, in terms of delegation of authority and practices that were applied at the PIC. He had no obligation to tell me.
Excuse me, will you repeat that?
So my answer is that I cannot make a view when it relates to work about what Dr. Dans believed, and I think he's the best person to answer. But I can highlight in terms of our professional relationship that he was not obligated in any way to tell me.
I can't understand what you're saying, because we just had the delegation of authority which you agreed to that says there was an obligation in terms of the policies of the PIC to agree beforehand with you with regard to this transaction.
Like I've highlighted through you, Commissioner, to say that that was not the practice. As much as the delegation of authority highlighted that, that was not the practice. And you see that in terms of the resolution of the 3rd of April 2019, when the board approved the revised delegation of authority, they've removed completely the involvement of the CFO because that was not the practice as it related to listed.
Can I just get clarity on this matter? Where the delegation says must agree beforehand, does it mean that both of you must agree?
So hence why, with the complication of that one, and hence why it does subsequently, because it was not actually the practice, that you can't agree beforehand heading to PMC. So you have to, so the word agree beforehand, and that's the confusion, that you cannot agree up front before PMC a transaction. So agree beforehand in just its nature, but not necessarily applicable there, is that you must be notified.
No. What I want to find out is that, you see, the agreement, or rather the DOA, has B and, what's the other one? You and the CEO. And my question is, if there is a transaction that must be agreed on beforehand, does it mean both of you must agree, or does it mean one of the two, or any one of the two can agree with the other side, or must it be both of you at the PIC that must agree?
So through Commissioner, and I think maybe the answer you'd say it's long-winded. So that was the problem with the practicality of it, and that was not complied with, that you can't agree beforehand on a submission to PMC. So a B means agree beforehand, hence why I'm highlighting that in the revised delegation of authority, the involvement of the CFO has been removed completely, because it was never the practice.
So at that stage, if Dr. Dan or Dr. Machila was of the view, or felt that a transaction must be accepted and the PIC must or can invest, he didn't have to come to you and say, do you agree?
So I want to confirm that, but also provide more evidence. So you'll see, and I'm going to exclude on the ordinary course, an appraisal report that is submitted by the members, by the deal team, would not have any of our signatures. So whether they engage with Dr. Dan prior to that is not necessarily information that I'm privy to. So I can only highlight the practice that was used at the PIC.
I want to just stay with this a second, because that means that you have a delegation of authority that you don't comply with. This wouldn't be the only one that says practice was different, and therefore other delegations of authority would have to be going through one by one to see which ones you abided by or didn't, depending on practice. That would be the first question. Is this the only delegation of authority that you can say, well, it doesn't work, so we don't do it, without changing? Because this is prior to change. Second, is this is actually an obligation set by the board? The question may well be, and I think it's a little bit of obfuscation on your part, and that may not be intended, but as far as the recipient is concerned, it looks like obfuscation, because this isn't simply about agreeing. If you're saying we can't agree on the deal, but this requires consultation, this delegation requires talking to each other. Therefore, it is not necessary, although you may say it doesn't work in practice, a deal of this size in my view, given that this is an instruction, it's an obligation, would say, do we actually think it should be submitted? What is our thinking about it? We may not decide, yes, we're not taking the decision, but both of us are in actual fact in support of this, that there would have been some discussion to meet the requirement of your obligation. What you're also saying is that there was no discussion whatsoever. So there was a total ignoring of your delegation of authority, not whether it worked in practice or it didn't. Because there's two distinct questions. We have an obligation, we think it doesn't work in practice, but at the minimum we're doing is consulting on the matter so that we're both comfortable that it goes forward. Right? Which didn't happen. Is that correct?
So it didn't happen, but can I provide more? So the issue that came, if you, and in my view, if you discuss a transaction before PMC and you agree, then the manner, then you're affecting already the consensus that
I'm
needs
not
to
saying
be.
whether
So
you
I'm just
agree
saying,
on the deal.
yes,
I'm saying there was consultation, that it goes forward to PMC, so that you would have paid attention to your delegation of authority, although in an amended form.
So what I confirm as the DOA regarding my involvement, that I'm assured that we did not comply with, is the listed one. Hence why it was reversed. It was revised to remove my involvement because it was never complied with in practice. So yes, we're not in compliance with the delegation of authority.
Had you notified the board that this, before this question, before this kind of issue, that at what point in time did you notify the board that you were not compliant with delegations of authority of this kind?
So when, and I believe I wasn't present when they highlighted to the board the removal of the CFO from the complete delegation of authority of listed, highlighted because it was not being applied with practically. So I would believe that the team that presented the DOA to the board did highlight that.
I'm not talking about this deal. I'm talking about the fact that this was not being met in practice. At what point in time did you, as a CFO, saying we are not meeting our obligation to the board, that had been taken? How long had you not been meeting this obligation? 1 month, 1 year? When did this go to the board unrelated to a transaction to ask for an amendment?
So for a couple of months, we've been asking for amendments in terms of the delegation of authority. And therefore the board, it's only now in April that they've approved the amendments of delegation of authority. And if I recall clearly, I think there's an audit finding regarding the full compliance of the delegation of authority as it relates to listed.
So at what point in time did you stop complying with this delegation of authority?
So in practice, it was never as a result of consultation agreeing with me prior to PMC that was not complied with.
And therefore, although this was not complied with for some considerable period of time, it was only post this event, or a couple of months prior to this event, this particular transaction. When was it that the board was notified that you are not compliant and asking for a change to the delegation of authority, unrelated to a transaction?
So I'm going to answer it. So to provide. So I don't think we've ever gone to a board and said, as it regards to my pre-involvement to PMC. But in my view, we took it upon that my involvement comes in terms of PMC. And I think the one key things that we had done, and even you see in the change in terms of reference, was that any pre-involvement by myself or Dr. Dan prior to the transaction poses a risk.
I understand that. I'm not questioning that. I'm questioning, given that you were not in compliance with a serious delegation of authority that relates to significant funding, that at what point, because it's a delegation from the board of an activity. And if I understand you correctly, because you don't seem to say yes or no, the question is, at what point, you were non-compliant with this for a long period of time, from what I interpret, but at no point in time did you, as a CFO or acting CEO, deem it appropriate to raise with the board that you were non-compliant. It might have been for very good reasons. But the question is, as far as a board is concerned, this is a delegation of authority that's being effected. At what point in time, yes or no, did you look at it to say, I have not raised that with the board, we have not raised that with legal, we have not raised that with the company secretary, to put this on the agenda of the board and ask for an amendment until much, much later when non-compliance with that had been in practice for some time?
So, like I've highlighted earlier on, is to say that we had taken it to board to say we need to revise it non-compliant. So did I go in and say to the board, specifically in my position as the CFO, the answer to that question
That
is no?
wasn't my question. My question was it raised with the board timeously in relation to non-compliance, that as practice this doesn't work, we want an amendment to that delegation? How long had you been non-compliant before that was raised with the board?
So I'll have to take through, to go back and say when, but in my time, as it relates to listed, and hence why we've gone to the board, we had gone to the board and urgently said we need the revision of the delegation of authority, because certain things, especially in the Bs beforehand, they were impractical and they were not being applied in practice.
Advocate Lubbe, can we find out from the company secretary when this was taken to the board and by whom?
It's noted, thank you.
Second question is, you've spent a lot of time in your testimony dealing with material non-disclosure and allegations of fraud against Mr. Siani. Sorry, go on, yeah, sure.
Just want to get done with the delegation of authority. I just want to understand it and how it works. It is said here, I interpret it to be saying, for a strategic investment listed for amounts greater than 3 billion but less than 10 billion, A, for final approval, I suppose, B, must agree beforehand. What must be agreed beforehand?
So, Commissioner, I'm going to try to just to give examples. So, the practice is that if you refer, you've got a B under risk, being that they have to submit their risk report. So and the word agree beforehand is not that they must agree that the transaction is valid, but it's that they must submit a risk report. If you see there's another B inside the executive head of legal, and that relates to that they must submit a report, so they'll submit their legal report. So hence why I'm highlighting that the B, in relation to my engagement, I do not make a submission. I don't make a submission before PMC. Hence why that was not applied with in practice.
I'm not sure that I understand. You interpret the word agree otherwise, meaning that a submission must be made. I don't understand.
So the word agree, because it's consistently applied in the policy and in the delegation of authority, and it's not separated. They agree beforehand, and I was highlighting, and you'll see it even in the new revised delegation of authority. Now they include the executive head of investment management. It is about, it's not that they agree that the investment must go ahead, but they must submit a report. Because if you look at in terms of the practice that's done when you get to PMC, because you see the A sits at PMC, at a later date the A sits at the IC, is that risk, legal and ESG will submit reports regarding their due diligence per outcome. So it's not that they must agree the investment must taken, they must present, and that's been the practice.
Or does it mean it must be agreed that these submissions have been made or have been delivered?
So what we will make sure when the PMC happens is that we have an ESG, legal and risk report and a deal team. So hence what I'm saying is the word agree, don't just look, it's that they must submit. And if you see their reports of risk and legal, they're not signed by either of the two executive, because they submit a document to a PMC. And you'll see even further when you go to 6.1, when it gets to the IC, you still have the Bs inside the risk guide, the legal guide. So it's not that they must agree, but again, if a transaction, the approval limit is at IC, they must submit a report of the due diligence outcome, and that being the practice.
Advocate Lubbe, can you take this up? Because
Mr. Commissioner, yes, I want to make it very clear. What the witness is responding to cannot be correct. If If you look at this document, it says, when you look at the top of it on the left-hand side, final approval, B, must agree, D, responsible for initiation. Now, if you look at 6.2, who is responsible for initiation? The CEO is responsible for initiation. And for strategic investment listed for amounts greater than 3 billion, but less than 10 billion, there must be an agreement beforehand, before this is initiated. That's the logical interpretation of this document. It cannot be otherwise.
Through Commissioner.
Sure that I should give you the indulgence. You're a witness, you shouldn't be asking questions, but if
No,
it's...
I'm providing
if
clarification.
If it's for providing clarification, that's
Yes.
fine.
So if you refer to 6.2, the D sits under executive head of listed, doesn't sit under the CEO. So it's initiator, and if you see the Ds, they even go to the GM of listed in equities, to the GM. It's just highlighting that any one of the guys is an initiator. And then, maybe what I would request the Commission to look at is the practice that, as I understand, is as much as this is what is written, that agree beforehand or final approval, to actually look at the practice, especially when it relates to the B and the D, and to say, what was the practice as it related to the B and the D?
Can we perhaps move on? Because
Before you, unless you want to say something. Before we move on, I think that this is really a great concern, because it's not what you do in practice, it's what the board expects of a delegation of authority that matters. And as an acting CEO and a CFO, it is of grave concern that it's open to interpretation. Your clarification on D does not help, because that is very clear. It is what is the role of the CEO and the CFO in the delegation of authority as expected by the board. And if it has been amended without that clarification of what the practice needs to be, because then it's not a question of whether the CFO has been excluded from it, is the appropriate practice that would meet a board standard of delegation of what they expect in place. And that, I think, is the question that we need to be looking at, not to look at what the practice is. A practice is clearly in violation of the DOA. That is the reality.
Exactly. You see, that's why I want clarity. I wanted clarity from you as to what it actually means. Because a submission by risk or whatever does not come into agree. I want to know what should be agreed, as the delegation says, beforehand. But you've tried your best. I think you've got nothing more to add to what you've been trying to say. But we need to interpret this, and that's why I needed a lead. You can't say, this is our practice, so that is what it means. That's not how you interpret documents. Okay.
Can I ask you, it is now common cause that this very important fact of the signing of the irrevocable offer was not disclosed to you. And we have this policy of the PIC. This document we're discussing now is a very important document. The question is, why did you not include this document in your statement?
Chair, the document is included in my statement under MM 27.
I then apologize. Can I just check?
Yes. It's inside my statement.
Advocate Libber, are you
Please proceed.
You done? I want to come back to the question about the statements you've made about material non-disclosure and fraudulence to Mr. Siani, about Mr. Siani and his evidence. But in the meeting, I mean, Mr. Siani we've had the evidence, he's indicated what pressure he was under, what his own views were as distinct from what he submitted and so on. So we've had that evidence, and if need be, we can have him back to confirm. But at a meeting in which you chaired, the PMC meeting, you were acting CEO and you were chairing the meeting, is that correct?
I was an acting CEO, but I was the acting chairman.
You were acting chairman,
But
and
not the
Dr. Matshepo came back to that meeting, although he had been on leave.
Correction, he was present at the meeting.
He was, that's what I'm saying?
Yes.
He was
Correct,
present
he
at
was
the
present at the meeting.
Correct? He was present at the meeting. Did you ask him why he had specifically come back, although he had been on leave?
As highlighted in my statement that when I undertook the remedial action, I did have a discussion with him regarding that I will not allow the team to release the funds until the necessary deliberation has taken place, and therefore he then felt he came back to the PIC. If you refer to one of the annexures where you see an email from the company secretary informing the PMC members of that the CEO has requested that we have a PMC meeting either on the 20th or by 9 o'clock on the 21st, hence why I believe he came back.
And the question would be, given that he was present in the meeting, and as I said, you've spent a lot of time in relation to Mr. Siane's non-disclosure, would you regard Dr. Matshepo's non-disclosure in a meeting taking that decision as a material misrepresentation?
I do agree, I do regard that he should have disclosed to the meeting.
So it's a material misrepresentation to that committee?
I agree, Chair, but can also hence why in May 2018, the round robin which the deal team provided, which is one of the annexures, highlights that the people who had known about the irrevocable, that they did not disclose it. I think that's one of the annexures,
No,
yes.
that is clear. All I'm asking is, knowing that now, and you were chairing the meeting, would you regard that as a material
Yes,
misrepresentation?
So I would regard that it was very critical that they needed to have told us, because they should have told us that the irrevocable had already been signed.
They should have told you, but I'm asking you slightly differently. Because it's not just they should have told us. Is it a material misrepresentation? Because it would have meant a very different PMC discussion if that had been disclosed.
So in my view, given, let me make, and I'll use the EdCon example and come back.
Please use this one.
Okay,
I don't want other examples. I want to know your thinking of is this, all I'm asking, in your own view, is it something that you'd say, okay, he should have disclosed it? Or is it a material misrepresentation because all of you had a discussion without knowing that it had already been signed and done?
So it was an important document to be notified to the PMC deliberation that was signed. But given who the PIC is and its ability, I do believe that the conditions that were posed by the PMC, even if under the irrevocable had already been signed, the PIC would have been still able to post them to IO.
Oh, I don't think we're going to come to that later because we're going through this in sequence.
That's fine.
That's not whether you take remedial steps because you didn't know that they were required at that point in time. You've put certain things in. We're going to come to that. So you are not confirming that this was a material misrepresentation to that committee. You don't regard it as a material
I confirm that it was critical that they informed.
That's a different question. I'm asking you whether you do not confirm that this is a material misrepresentation. You don't regard it as a material misrepresentation.
I've said it, I believe it was critical. It was a misrepresentation, so that they should have disclosed the information.
Thank you.
You agree that it was a misrepresentation. You say you make mention of Mr. Siane that he deliberately didn't disclose. The same must apply to Dr. Matshepo, isn't it?
Yes, through Commissioner, the same applies. So in me, maybe making specific to Mr. Siane's reference, is that it's in response to his testimony before the Commission. Hence why I just highlighted, because it's me, my statement was prepared in an attempt for me to respond to statements that have appeared before the Commission and any allegations or insinuations that have been made directly towards me.
Can you just remind me whether the agenda for that meeting is amongst the papers that you have?
Not inside it's not inside the annexure that I have, but I can confirm that at the meeting of the 20th, and I think I allude to it in my statement, where I say what are the two things that the meeting discussed.
Were those the only matters that were to be discussed? There was nothing about ratification that meeting should have looked at?
No, Commissioner, the ratification only took place the following year in May 2018, post the internal audit raising a finding.
But is it possible for us to get the agenda, a copy of the agenda?
I believe if you ask the company secretary, yes, they can provide it.
Yes, it will be made available, Mr. Commissioner. Can I just place on record, Ms. More, I apologize. You did include that as an annexure to your statement. I apologize for that. Now, before the meeting of the 20th of December 2017, surely the financial team must have been in constant contact with PSG, the sponsor of this transaction.
Maybe elaborate, who's the financial team?
I'm talking about your financial team.
Oh, the finance team.
The finance team.
So the finance team, in terms of contact, I'm sure they would have had discussion, because PSG being the one thing that the finance team will need to do is send through a form that is confirming settlement, because they're matching.
The two people, I suppose, involved is Mr. Brian Mavuka and Asanda.
Right.
Are they in your team?
Yes, correctly, in my team.
Did they discuss this interaction with PSG with you at any time?
As I've already highlighted in my statement, Mr. Mavuka discussed with me on the morning of the 19th. So in terms of segregation of duties of the PIC, Mr. Mavuka doesn't discuss with me everything. If you recall in my statement, I highlighted that when you had referred to a question earlier on, that on the 19th, he had called me to inquire if I've provided the personal details to PSG.
So would it be correct to understand you correctly that before the 19th, there was no discussion with your finance team about this transaction?
Maybe to just confirm. So I'm not saying there was no communication between PSG and the finance team. What I'm saying, there was no communication between the general manager of finance and myself.
Before the 19th of December 2017?
Yes.
And there was also no discussion with PSG, between you and PSG?
I've never contacted PSG.
Can funds be dispersed from your department or out of your department without you knowing?
Yes, the releases, if you remember, I made reference to Section E of the Delegation of Authority that says at a certain, one of the two releases can release the funds. And I've highlighted in my statement that in my time as a CFO, I can't even recall releasing.
When you signed the disbursement memo on the 19th of December, you knew that at the time of signing there was no PMC.
If you refer to my statement, I had interpreted the word as part 2 of the disbursement memo that says ratify at the next PMC. I interpreted those words to be meaning that they had reached a round-robin resolution, and therefore this would be ratified at the next PMC, which is the process in terms of the terms of reference. So at the point of signing, the only time I actually found out that there was no PMC approval was when Mr. Magula, I called subsequent to me signing, I called and he informed me that there was no PMC approval. Hence why I then requested the General Manager of Finance not to release payment.
So on the 19th, when you signed, you were informed by Magula there was no PMC meeting?
Not when I signed, after when I inquired. If you refer back to the disbursement memo, you'll see I scratched out approved or not approved, and I confirmed funds are available. Then I made a note for the inside the memo that inquire from risk and inquire from ESG if they should be part of this memo. Then I further on my own proactive side, went and I called, after I'd signed, which was around after 3:30, I called Mr. Magula and to find out his view in terms of risk. It is when he highlighted to me that this transaction has not been approved by PMC, and I subsequently then asked the General Manager of Finance not to proceed.
Have you ever signed a disbursement memo before a PMC meeting?
In my recollection, I think before PMC, this was the first time that I'm aware of that there was a disbursement memo before a PMC meeting.
It's extraordinary and abnormal.
Sorry, Commissioner, can I ask, is that a question?
Is it extraordinary and abnormal in the PIC process to do that?
So it is abnormal to sign it. Okay, it is in contravention of the delegation of authority to have a disbursement memo prior to approval.
Why then didn't you cancel your signature?
Like I highlighted, after my discovery of this, I then told the finance team not to use that memo for its intended purpose.
Did the finance team, and I think you've already answered, but I just want to check it again. Being now aware that there was no PMC and you've signed this disbursement memo, did the finance team tell you that there's already irrevocable offer signed by the PIC?
So like I highlighted earlier on that Mr. Mavuga, in my telephone conversation with him on the 19th, he just highlighted to me that PSG had called him and he was inquiring whether I had given them his personal number and that there was a transaction that required, because it's a confirmation of settlement. So he didn't highlight to me regarding the irrevocable having been signed.
I assume you signed the memo before getting the agenda of the PMC meeting?
So remember, the PMC meeting, Chair, through Commissioner, was only scheduled post the memo.
Yes, it was scheduled for the 20th.
Yes, but it was scheduled only post the memo signing after me discovering that there was no PMC resolution.
Oh, so the memo was signed after that meeting?
No, before. So it was signed on the 19th, and then after me having contact with Mr. Makula and he highlighting there's no PMC, it is then the PMC subsequent to that was scheduled. I don't know if that makes sense.
So you signed before you got the agenda for the meeting?
There was no meeting when I signed. There was no scheduled meeting.
Was there no notice that there will be a meeting on the 20th?
No, there was not. The notice only came in on the 20th in the morning.
The morning of the 20th?
Yes, Commissioner.
And you got the agenda only after that, I suppose?
If you recall, Commissioner, I highlighted that I had discussed with Dr. Daniel Machila to say that this transaction cannot proceed. Hence why then, in terms of the terms of reference, was that a special meeting can be to deliberate the transaction. So I don't know if that provides an answer.
I'll be happy if I can know when you received the agenda, if you did receive an agenda.
So if you refer to one of my annexures, I'll say the official agenda was sent on the 20th. If you refer to one of my annexures, Commissioner, it's where I asked the General Manager of Finance to go to the company secretary and inquire if there'll be a meeting scheduled for the 20th at 1 o'clock.
Can I just ask a question? Because it may not have been the intent, but given what we know, that you have an irrevocable on the 14th, which I'm not saying it's an error, I'm saying you didn't open the email, but you would have known if you'd opened the email and read that. So as far as Victor Siani is concerned, he copied you in. He would assume, I assume, that you would have opened it or read it, you had the opportunity to do that. Even if it was, as you've explained in your testimony, you didn't because it wasn't addressed to you, but it did contain that information about the irrevocable. We then have all of this happening on the 19th and a listing that was intended to take place on which date? 21st or 22nd? 21st. So this is I think it's 21st because the listing was due to take place on the 21st. So all of this is happening with a listing happening on the 21st. Why would you assume that it's not the PMC meeting that you've called is not to ensure you've met process rather than content? Would that PMC actually have had the ability to say no when you've got an irrevocable, you've got the money, as you indicate on paragraph 6, 8, 10, you've got the funds, and I'm going to come back to that, but the listing is due for the next day. Would the PMC, in all fairness, have had the ability to say, having considered all of the matters arising, and I'm going to come back to some of that later, had the ability to say, sorry, but we don't actually agree with this and we're not going to go ahead?
In my view, is that because the PMC deliberated, they could have come back with whatever outcome that they wanted to.
You are quite comfortable that that PMC had the ability, notwithstanding listing the next day or anything else, to say no?
In my view, they did.
Have they ever done that before on an eve of a listing?
I can't recall if there's ever been an eve of a listing, but I can say there's been transactions which we've declined.
Oh, absolutely. But there's a different question to declining a transaction in the normal work of the PMC to a discussion of the PMC when you have the chair, the CEO having signed an irrevocable, the PMC meeting as an urgent matter on the eve of a listing to be able to say, are there things here that we would be uncomfortable with? I mean, let's take the example of taking your own questions, and let me come back to it in sequence rather. I'm just asking whether rationally, logically, you would say that PMC was unfettered in its deliberations.
So, through Commissioner, so the key thing in any deliberations is the documents that sit before that committee. So all the documents that sat before the PMC of the 20th of December supported the transaction. So it is quite rare, let me say, when risk, legal, ESG and the deal team put together an investment case and support that the PMC would decline.
Ask a different question. Okay, if we could perhaps move on. Is everyone finished with the questions on that? We'll come back. Okay, could I ask whether, given the size of this deal and the issues around it that clearly have materialized, whether a round-robin resolution is a means of approval for a deal of this size that the PMC would, I mean the PIC would take, and you as a CFO, are you comfortable with a round-robin resolution as the means of approval? Because a round-robin resolution, in essence, means that there's no group discussion. We give our view or not view, and you need 75%. So I'm not asking only about this specific one, but as a method of approving a deal of any magnitude, would you as a CFO find that an acceptable method of approval?
So, Chair, we put together the documents that give effect to processes. So in terms of the terms of reference, it is permitted.
I'm not asking whether it's permitted. I'm asking whether, as a CFO responsible for the good management of the organization for a deal of this size, to have it approved by a round robin. There's difference between what's permitted and what's possible, or what is all in terms of reference allowed, to what is good practice. And as a CFO, I'm asking you whether you feel that this is an appropriate way of approving a decision of this magnitude, and whether, so let's leave it at that for now.
So through Commissioner, given what happens at the PMC, even if you refer to the terms of reference and the standard operating procedure of the listed, round robin is necessitated inside the process of the PIC. So I can't say at this limit is right or wrong, because in circumstances that are required and due because the business needs, round robin can be used, and it facilitates efficiency. And at any given point, if any member believes that they need to have a meeting, they can have a meeting, they can request a meeting, the terms of reference allow it. So it is difficult to just say it's allowed or not allowed based on a quantum, because it's driven by a business need.
In paragraph 6.11.1 of your statement, no, not, you shouldn't. You talk about documents that were presented to the committee, and you use the word included, which means there were other documents as well. What other documents were there?
Sorry, Commissioner, referring that...
If you can remember.
So the documents that were presented in the committee, which I've just tried in 43A, was the requesting of the waiving of not having requested PMC 1. So it was a memo, and I think I've attached it as 43A. The B was, my 43B is the deal team's appraisal report. C is the credit risk report. D is the legal report. E is the ESG report, which is outcome of the due diligence. So those were the documents that were deliberated. I think the minutes also referred to them.
No, all I'm saying is that's in the list.
No, there was not, if I recall, there was no other document, Commissioner.
Okay, so you didn't mean to use the word included.
English second language.
Because that's what you're saying,
So
the documents that were there include these.
Oh, so, okay. These were the documents. So let me just say.
Oh, these are the only documents that were there.
If I could just come back to the round robin and your discussion earlier that you had not signed because you had not seen the documents. If I recall you correctly, to say that you didn't sign the round robin because you had not yet seen the documents?
So just to clarify, I say my statement, I highlighted that I had not interrogated, because for me to be able to respond to the email, I need
That's
to apply my
fine.
file to the document.
Yeah.
So it's not that I haven't seen
You hadn't interrogated the
the
documents.
documents,
By the time you had the PMC meeting, had you interrogated the documents?
looked at
So
the
you were
documents.
comfortable that you were familiar with the documents?
Yes.
Okay. Because then the question that I would ask you in relation to 610.5, if I could go there. All the evidence given to us up to now, as far as I recall, and I might be incorrect, so I would need to ask Advocate Libber whether there's any correction to that, but all the indications were that in preparing the documentation and the views on the IO transaction, the team had only looked at the preliminary listing statement, not the final, and that they had not received some of the annual financial statements of BT. In your paragraph, you say that they then confirmed they had received the final PLS and the signed financial statements. Was that subsequent, or when did that occur, given that in all the evidence in preparation of all of this, they had not seen those documents?
So, Commissioner, if you refer to the recordings, I think they will highlight that at the meeting of the PMC, the risk had highlighted that they'd seen the financials and they're comfortable, and I think I make mention of it. So what...
You're mentioning, that's why I'm asking, because all the evidence before us has been that they had not seen and did not have access to the final listing statement or the final annual financial report.
So, Commissioner, my responses will always be based on the information before me. So, my belief, if the Commission goes and listens to the recording, and hence why the condition that came with due diligence and stuff, it was because legal and ESG, if we refer to the conditions that were imposed by the PMC, it highlighted that legal and ESG should just make themselves comfortable and complete their due diligence, which the key highlight they had said they had not seen the final. Risk was excluded from that condition because they had indicated that they'd seen the documents.
Mr. Commissioner, we will follow that up. I think Ms. Marcus is correct in the sense that they only, at the date of the meeting, had sight of the final pre-listing statement, but they, at that stage they had no sight of the final financial statements of BT, which was crucial to this whole transaction. But I will follow that up.
Yes, Mr. More.
So, Commissioner, can I maybe request that also the recordings, because if I recall, memory serves me correctly, the final signed financials, I think they were in annexure to the pre-listing, the final pre-listing statement, and that was actually discussed. We had seen them in that, yeah. So if I can maybe request that you also listen to the recordings of, because everything that transpired is based on the information that was presented before the committee.
It will be followed up and it will be reported after the lunch break, Mr. Commissioner. Sorry.
I've got two questions on this one. Let's go to 6.11.13. 6.11.13. It's about the valuation of the company of IO. Are you saying that the PIC was happy with the valuation? I mean, with that statement, just as a first question?
I confirm, because the deal team confirmed that they believe a PE of 6 times was reasonable given where it was. So the deliberation was that even in the appraisal report they highlighted.
Yeah. You know, we had Mr. Malik Sali here, and he went, we went to some great length to say the revenue figures were very much stretched, and the aim was to get to closer to 1 billion rand in the earnings, so that 16 PE could equate to about 15 to 16 billion rand. I mean, what do you say to that? I mean, the figures he said were quite stretched.
So 3 commissioners. So that was one of the deliberations, and even if you refer to the risk report, they highlight that the revenue, it's a medium risk that the revenue will not be, the revenue being the prime numbers. Hence, I believe that we then put certain conditions, because the key driver in reaching that revenue was, 1, the BT transaction had to take place, because the BT transaction was going to expose the entity to certain investment. 2, one of the key things they had highlighted at the time is that, and it's a fact, that what would have made IO, and considering the BT, would have made them one of the most empowered ICT entity on the JSE, which would have meant that they're able to increase their revenues, because at that point in time, I think the new BE codes were now effective. And one of the key things, I think it was in the deliberations that came through, was that most of the customers that they were going to be approaching also related to customers that BT already had. So it was not going to be trying to find new customers, but that the BT clients will be seeking more empowered companies, so that in nature will increase the revenue of BT. So hence why I believe the condition that we put in to say that, it is quite critical that you embark on what you said the money is going to do, because then it gives the outcome of that, it is what the premise of the investment thesis be.
The next one is that the PIC says that it doesn't pay for the value that it creates, okay? Now you got sort of profits which are stretched to close to 1 billion rand from under 200 million rand. And then you got a PE of companies which are like operating for the past 10, 20 years. And the PIC says it doesn't pay for the value that it creates. I don't understand that you can pay 16 PE on stretched profits. I mean, surely there is no return after that, generally.
So if I recall, Commissioner, that PE was also based on that there will be ultimately return. So PIC is a long-term investor. So if I recall, the PE are based on the revenue assumptions for 2018, and that ultimately you'll see the change in the IO transaction, and that IO will become a leader in terms of its peers. And in terms of paying, so this was not necessarily paying, and I think Mr. Mulabatz in his statement did say, highlighted that we also saw this as a spec, in that's why one of the key conditions was that the funds should be used solely for the acquisition, should not be used for any other things, because we saw as the PMC that if it's in acquisition that you're going to get growth, and hence why we also put the condition that any acquisition of about 10% of the market cap, we should be consulted, because I deem it was critical to make sure that it is the right assets that are being acquired that would actually see this business beyond towards the investment thesis that we're premised on.
Yes, but if you project 1 billion of earnings and you are placing it at a high PE, I mean, surely you are not looking at any returns for the next couple of years, isn't it?
So, Commissioner, maybe to answer that, if you recall, so the strategy of IO at the time was that the next 2 years it's going to be an acquisition. So they're going to be acquiring. So, and the PS is a long-term investor. So it was that the first 2 years, and you know, the spec comes from the private equity model, that you've got a committed period where you're ramping up, and then after the committed period, you're going to strike. So the view was that you're going to have 2 years where IO's primary focus is going to be acquisition, and after the 2 years, you're going to start seeing even beyond, because then they're going to be buying the things that are going to actually make sure that their revenues materialize and goes beyond.
Next one, let's go to 6.11.8.3. Yeah, so I just wanted to check again. Yeah, page 31. I just wanted to check. You are saying 6.11.8. Are these conditions precedent? Because in 6.11.8.3, the put option was signed months away from the listing and all that. So I just wanted to check, wasn't this supposed to be in place before you signed the subscription document?
Sorry, can I just add to that? If you look at 6.11.10, it was that the board specifically, the meeting specifically resolved that should IO not agree to conclude a put option, the funds would not flow, so that the put option was an imperative within a certain period of time, but actually only got signed in October a year later. How does that become a condition precedent?
So if you refer to that part of my statement, I go that if you listen to the deliberation, that was the discussion that there must be the criticalness of the put, and that the undertaking, and I don't want to maybe use the word criticalness, the undertaking of the put being critical, in that one of the discussions, it was that what happens in the event that IO doesn't support a put. And the discussion was that then you tell them that the funds will not flow. So, and that's why I've also just included as part of my document an annex chart which details what happens in the implementation, that the deal team will send a letter to the committee and inform. So the put should have been actually agreed upon in terms of that, because it was what the PMC, one of the discussions within the PMC regarding the put. So one of the weaknesses I do take is that the resolution, I guess, did not explicitly write that this is a condition precedent or it's condition, but I think the deliberation and the deal team inside the deliberation understood which one was critical.
But I mean, it's common sense that you can't ever put months later. I mean, besides the fact, you know, of the minutes and all, you can't ever put later, isn't it? The share price starts trading now, and it can go 20% down in the first day of trading.
I agree, Commissioner, that you need to have the put up front. And if I recall, I can't recall if it's one of the documents I saw, Mr. Siani highlighted that around 3:01 on the 20th, he had communicated to AO regarding the resolutions that the committee had made, which one of them would have been the put.
So can you say that there was a breach here? I mean,
I'd say there was a breach because that was a condition posed by a
and it's a
committee.
huge one because it's no protection really in many ways, yeah?
It's a huge one because the intention of that was to guard against the revenue
Yeah.
and the strategy not being carried out.
All right. The final one is on,
Just want to stay on the same point before you move on, if you don't mind. As I recall, I don't have the document just quickly to hand, but as I recall, that the price of the put was at about 22 Rand. So it was half the value that you actually had, and that would have been, I think, a critical question in a put in the first place. And second of all, I don't recall quite who advised that this was inappropriate and should not be agreed to, and yet it was signed off by Dr. Machila at that level, notwithstanding the team's advice not to put a put at that level. So even though there were a number of things here, it wasn't just that it wasn't implemented in an appropriate time and put in place appropriately the level at which it was set, and then notwithstanding that, there was recommendation that it should not be put in place at that level and at that price, and it was inappropriate. It was signed and agreed to by the PIC. You're aware of all of that?
So I confirm I am aware of that, but I would like to say the deliberations on the 20th of December 2017 at the PMC was that the put at a minimum should protect the capital.
I'm asking a slightly different question here because, yes, that's what the PMC, and we're going to come back to some of these questions just now, but what I'm also asking, as again taking your role as a CFO, if you have a put that is disadvantageous, are there steps that you as a CFO need to take to see that the value of the investment is in keeping with what the PMC decided as its intent? And if this occurred at that kind of time, what follow-up was made by yourself as a CFO or your team to say, where's the put, why is it at that level, why was that agreed to? That's why, to me, it's the role of the CFO in maintaining the sustainability of the organization and the integrity of the decisions that I'm looking at here to say, what were the next steps, given that this was not adhered to, that this was a violation and a serious breach? What steps were taken to address this, not only for this transaction, but for any future transaction?
So in answering that, I think first the critical point is the role of the CFO as defined inside the PIC, to say what role we play in terms of, so the role regarding the management of the portfolio of listed, it's that duty has not been segregated to the office. It's not the responsibility of the CFO. That duty it's the duty of the executive head of listed in part and parcel.
Or is that a result of your reorganization, that you have delegated that downwards, and therefore you don't have an oversight role as the two executives in the organization, the CEO and the CFO?
So in answering that, maybe I'll just, if you allow me, Commissioner, to provide background. Prior to my appointment, the CFO actually played no role in AUM. They never played any role inside the AUM. So it was now post my appointment that we were now introducing the role that the CFO plays in terms of certain elements. Hence why I'm highlighting that you would see, if you look at the delegations of authority between listed, unlisted and property, you will see now the introduction of the role of the CFO. So I would say that hence for me it's quite critical that one highlights the segregation of duties and the role which the PIC in particular has put on the office of the CFO.
I just would ask whether you think there's a need to, in the light of all the information that is coming out about the functioning, whether you think there's a need for a review of the role of the CFO in relation to the overall working of the organization?
I'd agree, but what I would also highlight is not just the CFO. I think one of the key is specifically of all the assurance providers, because they are there for checks and balances. So there needs to be a proper review of to say, where's risk, where's legal, where's ESG, more specifically on the listed space, because I think over the years we've improved more controls in unlisted, and we need to. And even if you refer to the new revised delegation of authority of listed, you'll see that the 6.2 no longer exists.
But it's a very questionable issue around the DOA, because what you've indicated earlier is that what the DOA says and practice could be very different.
Hence, Commissioner, yes, I agree. Hence why I'm saying there needs to be a review of the assurance providers' roles. Where does risk play? How does risk play post-monitoring? And especially in the listed space, and to say how we go about in the IPOs. And I can just give you an example. So one of the key things with the change in the new delegation of authority we did is to define pre-IPOs as unlisted and not refer to them as listed, because of the type of risk they expose. So that was a project that we were embarking on to say, given the lessons we've learned and things we've seen, because certain things transpired before this commission, we need to go back and relook at our processes to enhance them.
The final question from me is on 611.8.5. If you can just read that first, and then the question is, was this done, and was this a CP or done?
6.11.8.5.
Yes.
Okay. Implementation of conflict of interest policy to govern any related party transaction.
Yes.
So this was a post, because it was about putting together a conflict of interest policy. And just to give you background, this stemmed from the risk report, where it highlighted that there's a potential risk of having related party transactions. Hence, and if you listen, I think, to the deliberation, we deliberated on this to say that we need to guard against that, because you need to make sure that we are understanding what related party transactions are taking place. So, Commissioner, I can't say, I haven't updated to make sure all of the conditions that have been met. So I haven't gone to the team and say, have we put together the policy? So I can't confirm.
Yes, because from what we heard in this commission is that IO had done quite a number of transactions which are related to the various companies within the stable. So I don't know whether this policy was there or it was not there.
So, Commissioner, at the point of approving the transaction, it was not there. So hence it was a condition that there must be a policy that relates. And if I recall correctly, at the deliberation of the meeting, we're like, it shouldn't just be a policy, but that policy should look at things like how to determine, when you have a related party transaction, how to determine the value. Like, the value should be independently done, and how old the valuation should be for you to consider. So those were the discussions that happened, the deliberation. So I think I'll have to ask the PIC team to confirm if this condition was actually concluded.
Yeah, thank you. Thanks.
This be convenient to take the agenda?
Thank you, Mr. Commissioner.
We'll adjourn until 2 o'clock.
Still okay?
So just to clarify, so if you refer on the 19th, inside the equities bank account, I think there was about 2 billion on the 19th, or 1 billion odd something, and then there was 5 inside the STD 004 being the main account, which is used by fixed income to transfer funds. And I think if Advocate Lab as part of the evidence, they will see transfers between the two accounts.
But this you handed in, or you have it as an annexure to show that there were sufficient funds at the time that you signed that there were funds.
Yes, Commissioner.
Is that on the 19th or the 20th?
On the 19th.
And given that payment would be thereafter, you're saying that in the subsequent days or 2 days between 2021, there would still be sufficient funds to pay?
Okay. Yes.
Then why did they have to liquidate assets to make the payment?
So if you recall in my statement, I highlight that at any given point in time, we don't keep as much reserves as sitting, but we'll have calls that are sitting with the fixed income team. So in the event that there's money that is needed, the fixed income team will call the money to come in. So in terms of settlement, the fixed income team, if I recall, they will settle at T+1, and in terms of equities, we have to settle at T+2. So in the nature is that we do not keep at like a 10 billion bank balance at any point in time, but we make sure that because the mandate allows about 2% to sit as cash, but cash means money markets.
That's a different question, because in terms of this transaction, as I understand it, and I would be guided by Advocate Libbe if I'm incorrect, you actually there was an instruction to liquidate assets, to create liquidity. And it was one of the mining houses that were a good investment that was liquidated to create the liquidity to make the payment. It's very different from putting money on whatever deposit it is and taking the cash out. This meant that you had to liquidate assets for that payment. So that's a different question. I mean, it would not be normal to liquidate good assets to pay for a new investment.
So, Commissioner, through you to just maybe to explain the process. So, in terms of fixed income, the fixed income team is responsible for the treasury function. So, normally, everybody on a monthly basis as finance, we will sweep the accounts of the guys and the fixed income team. And the fixed income team, when there's a need, they will liquidate. I can't remember which document I reviewed where Mr. Siani highlights that he actually went to Mr. Smith to highlight for liquidity. Now, in terms of the equities team liquidating, so they would liquidate based on the rebalancing of the portfolio. So at any given point in time, they rebalance. So when they are liquidating any assets in order, they'll be liquidating. And if memory serves the commission, that the one they said they liquidated was Anglo, which we were overexposure. So they were taking proceeds because, as per the mandate, we're overexposed to it. So they were recognizing the proceeds and the investment. But I think Ms. Khanewe tried to highlight which investments they liquidated. But I guess what I'll employ the commission to do to discuss with Mr. Leon Smith, who's the head of fixed income, who's responsible for the treasury function.
I would just prefer that we dealt with you as the CFO, because you keep referring us to other people, and I think that we're here to have a discussion with you. And it's really to understand not just the process of sweeping, because we all know how that works. The question is, it would have been, if there was a need for creating liquidity because you need to sell something to do that, I would have thought that you would be looking at your assets as a matter of routine, and you say, these ones are overexposed, underexposed, you would do your balancing as normal. I would not think it's normal to liquidate for an investment that you have signed for. I would think that it may be something that in preparation for an investment, you may liquidate. But not on saying we haven't got money to pay you today, we're going to pay you on Friday the 22nd, because we have to liquidate assets to create the liquidity to pay you. That seems like a different type of decision to me.
So, Commissioner, in response to that, I just need, in terms of the management of the portfolio, and in any given day, the main account being STD 004, we don't sit with anything beyond 2 billion, we sit. So what then happens is that, as I highlighted, that the fixed income team is the treasury part of the business, is that even in unlisted, if there's an investment that needs to take place and there's not enough cash reserve, the fixed income team will liquidate an investment in order to allow for the money, because what they liquidate, as I highlighted, the mandate allows about 2% to be kept as cash. That means it overnight. So we even liquidate because normally the client will give us like a 2 days notice if they have a drawdown. We will liquidate the cash, the money market, to avail the funds.
Liquidating money market is different from liquidating other investments, because I mean it's liquid. Money market is, the purpose of it is to be able to have cash to hand.
So, Commissioner, just to confirm, so the relationship is between finance and the fixed income team in terms of the process of the treasury function and making enabling finance to make sure that there's adequate funds at settlement date.
I want to conclude this whole issue of the irrevocable offer that was signed. You told the Commission that at the meeting of the 20th of December, you were unaware of that. Is that correct?
No, place on record, yes.
Yes, Commissioner.
And do you agree it would have been totally useless, unnecessary to talk about conditions precedent if you knew about the irrevocable offer?
Clarify, sorry, through Commissioner, just to clarify.
If there's an irrevocable offer signed, it's no use talking about adding conditions precedent because it's already signed, it's final.
So through Commissioner, in answering that, for me is the PIC, and if you then ultimately find what transpired with IO, is that we were one of the only investor. I'm of the view that even the irrevocable having been signed, those conditions, IO would have participated in them. Because as I highlighted, if you refer to the deliberations of the PMC, the discussion that happened was that if IO is not, and I'll specifically highlight that the key person that had that deliberation is Dr. Dan, who specifically said to Mr. Siani that in the event that IO refuses to put the put option, we need to tell them that the funds will not transfer.
And we know that that was totally ignored. The put option was not on the table, the funds flowed.
I confirm, Chair, that that's what transpired because this was only signed in October.
Can I again ask you, when did you for the first time discover the signature of an irrevocable offer by Dr. Machela? When was the first time that you found out about that?
I think I've tried to give the specific date that upon the upon my return, because the disclosure to PMC in May 2018, I wasn't around.
Can you recall that after this meeting, on the 20th of December, you were with the then acting company secretary, Vilna Low, to ensure that the resolution of this PMC meeting was correctly captured?
So through Commissioner, I confirm, and maybe to provide details. So Ms. Vilna Loeb, considering that I had chaired the meeting, the resolution of the meeting would be signed by me. She came to my office to highlight to me that we need to highlight the resolution that was prepared by herself in consultation with the legal team. I then requested to her that can I please ask her to get the legal team and the deal team to put together all the resolutions that were made and not just limit to the put option.
I have just been handed an email where Vilna Low wrote the following to Victor Sihane. Matshepo requested that we include all the conditions. Herewith for your input, please. I am currently with Matshepo. If you can please urgently respond.
So just to give context, so she, and I think it's understood, she came into my office with the resolution for me to sign. I then highlighted to her that, if I recall, not all the resolutions that were as per the PMC outcome have been captured. She then sat outside my office and then discussed with the investment team to make sure that they modify the resolution that's been put in place, and then she just brought it back into my office because maybe to just give, because you have to understand, so the printers are sitting outside. So she sat outside of my office to ensure that she had the discussion with the deal team and the legal team to make sure that the resolutions of the PMC have been captured correctly. So any email communication that she was having with the deal team and legal, I was not privy to. So all the information that I was privy to is the resolutions that she would give to me to sign.
The reason why I'm asking you this, and I think you have anticipated what I'm going to ask you, is he responded, "Hi Vilna, it is difficult to have the put option as an absolute condition because it still needs to be negotiated, and PIC has already given an irrevocable undertaking to make the acquisition." That is the response by Victor to Vilna. Is it your answer that you were not told about that?
On what date did that communication take place?
Around the
It's the
20th.
20th of December, Mr. Commissioner. It is 20th of December. It's the afternoon after the meeting.
So to confirm, Commissioner, the discussion that Ms. Villanelle had with me was in regard to the resolution. So I was not privy to the discussions that she was having on email with the deal team. And I would assume that the discussion she's having with the deal team on email will also include legal. So if need be, that we should look at what also legal, because they're the ones who advise with regards to what gets finalized. My request was that we do not just put one condition, but we put all conditions that have been posed by the committee.
And your evidence is that you didn't see this email.
So my evidence is that on the 20th, I did not see this email.
And Mrs. Villanelle did not discuss with you the content of this email.
I agree. She didn't discuss with me. She just discussed with me the resolution.
Thank you. I'm going to...
Sorry, Advocate Lubbe. Can you just reread the response to
I've asked for copies, Mr. Commissioner. It'll be here soon, so I'll hand it in. The response is, "Hi Vilna, it is difficult to have the put option as an absolute condition because it still needs to be negotiated, and PIC has already given an irrevocable undertaking to make the acquisition. Could we perhaps say," and I'll read the whole thing, "can we perhaps say PIC will endeavor to negotiate a put option at 30 days over a 2-year period with 6 monthly anniversaries?" It's part of this email. There are some other comments as well, but I'll hand this in as a exhibit. Just to conclude on that, you wanted to finalize everything that afternoon of the 20th, and you requested Vilna to assist you by requesting certain information from Victor Siani. Is that correct?
But the 20th of which date?
This is now the 20th of December, 2017.
So just to put on record, Commissioner, so the process is that the company secretary will bring a resolution to the chairperson of the meeting to sign it, which it gives effect to exactly what conditions that committee signed. So maybe for me, that was presented to me as the then chairperson of that day to say that I must sign the resolution to make sure, a resolution which captures what the committee deliberated on.
See what is important, that's why I'm reading this to you. She says in this email, Victor, and she also sent it to Sasa. Is Sasa Faku?
Sasa is, like I highlighted, so that is the legal advisor.
Victor and Sasa, Matshepo requested that we include all the conditions. Herewith, for your input, please. I am currently with Matshepo. If you can please urgently respond.
So through Commissioner to confirm, so what was presented before me was a resolution that had omitted certain resolutions, conditions that were given at PMC. I then said I will not sign a resolution that changes what the committee agreed upon. Therefore, can they kindly put all conditions that were put by the committee regarding the approval, in the sense that we cannot just put conditions that we like, we have to put everything that the committee resolved to do. So that's what transpired in that day. So when Ms. Velnalo presented me with a resolution, I then said, there are other conditions that the committee made, and they need to appear in the resolution. Therefore, can they go change it and make sure that all those resolutions are captured?
Thank you. Now, if we can again turn to that meeting on the 20th, because it was quite a debate with the evidence of the internal auditor. Was the purpose of that meeting to ratify or to approve the AO transaction?
So through you, Chair, the purpose of that meeting was to approve, and this is demonstrated by the documents that, as it relates to participation in IO, it was to approve, and that is represented by the documents that appeared before that meeting. The only meeting that was the only agenda item that related to ratification was the fact that PMC 1 was never requested. It's only on the 18th, not 18th, it's in May 2018 that the PMC highlighted that the decision of the 20th December 2017 should have been to ratify and not to approve.
Can I ask you this? In the case of an emergency transaction like the AO one, where the timelines are almost impossible due to the impending listing, would it be incorrect or illegal to combine PMC 1 and PMC 2?
So if the word illegal is a big word, so combine PMC 2. So my answer would be, in any given circumstance, depending on what's happening in the business, a request can be made. And there's been incidences where a request that the team will come, and I think in terms of my statement, I make reference to EDCON, where we went to IC to seek approval subject to the satisfactory completion of the due diligence. So sometimes in terms of our processes, it's driven by a need and the criticalness and the urgency, and therefore the team will look into it. If you refer to one of my annexures, which is the standard procedures in terms of the listed team, you will see that in terms of the accelerated book build, the standard procedure highlights that the team can actually come and later on inform the PMC, and that is driven in the fact that sometimes in accelerated book build, the listed team only have like 24 hours to respond. So it's driven by the business need and the rationale behind it.
The evidence till now before this commission was there was never a transaction like this in the history of the PIC.
So through you, Chair, in answering that, I'll provide. If you look at every documentation that related to IO, so if you look at the disbursement memo that was signed on the 19th, if you look at the appraisal report that was presented to the PMC of the 20th, the deal teams indicated that they commenced due diligence from the 16th of November. It only transpired in this commission that Mr. Victor Siani then indicated that he started due diligence post the 24th. So on every document that was presented before myself, he had indicated that, the compiler indicated that due diligence started on the 16th, therefore indicating that there had been about a month for the team to embark on the due diligence. as I've already highlighted in my previous comment, is that with the listed team, so that, if I recall, Mr. Siane's analysis of this has never happened related to his involvement with IPOs. But in terms of accelerated book builds, the due diligence being done with a shortened period of time, that does take place. So it's always the need, and we are guided by the deal team. You know, what the deal team presents before us, due to segregation of duties, we trust that they've carried out their duties with due care and skill. Moreover, because they are representative, so we are guided by them. So at no point, whether the disbursement memo or at the PMC of the 20th of December, did Mr. Siane highlight that he did not. Actually, if I recall, on the 20th, he indicated that in terms of valuation process of ascertaining the value of IO, he had done all the work he could possibly do.
Can we move to what was now called the ratification of this agreement? It's something I don't understand, and perhaps you can explain it to me. We have the undisputed facts that there was an irrevocable transaction signed, offer signed by the PIC, and at the meeting of the 20th, certain conditions were then attached to this signed agreement. How is it possible to ratify something that was not part of the original agreement with AO? You understand what I'm trying to? I signed an agreement with AO, and the terms are A, B, and C. Thereafter, unilaterally, I add further terms to this agreement, D, E, F, and G. Now I go to a committee to ratify that was not agreed with AO. How do you do that?
Just to confirm through you, Chair, is this in relation to the meeting of May 2018?
It's in relation to any meeting, but let's talk about the 18th.
So I have limited, and if you refer to my annexure MM37, you will see that the MM37, 37, it's the resolution that was ratifying the decision regarding with IO. I would like to highlight that during this period I was not present. So therefore the signature was by the acting CFO, it was not by myself. So now in trying to answer, I guess on a general principle, so I wasn't around when this deliberation regarding the ratification took place. So I don't have the context of exactly what the members what they deliberated on and what got them to conclude on this resolution, because from what I understand, it was a recommendation from internal audit. So ratification, in my view, is permitted by the law. It's permitted, and one of the key considerations that I think it has been highlighted in the PIC, that we need to start reviewing the process of when is something ratified and who should ratify it. And I think the internal audit have also raised that issue. Because ratification is permitted by law, but that we need to figure out inside the PIC where to manage our risk. Because if something is permitted by law, we need to just make sure that we manage our risks.
What I'm putting to you, and I don't want to engage in a legal debate with you, is this type of ratification is not allowed in law.
Okay, I will take your word. I'm an accountant.
You didn't participate in this ratification
in May 2018, but Chair, that time where I wasn't around at the PIC.
And you wouldn't know what they did, whether they withdrew the approval decision in order to ratify?
Chair, I think I'd actually attached the resolution. I'm just going to try. Oh, actually, point 37 is actually the resolution. And if you refer to page 2 and you refer under point 7 and under point 8, what they resolved, and I'll read it out.
Sorry, we don't have those pages. We only go up to resolution 4. It is recorded that
annexure MM37.
Yes, I'm on that. We only have up to 4, so if you do read it out, but then we would need Advocate Lubbe to get the additional
It's double-sided.
documentation. Okay.
If I,
Yeah.
sorry, Commissioner, I couldn't hear clearly what you just said.
I'm saying we don't have that part, so if you could read it out and if Advocate Lubbe can ensure we get that page.
Thank you, Commissioner.
Are
So,
you going to read the document at 37?
yes, I'm going to read it out. I'm going to read out the second page as what was resolved by the committee on that day. It is hereby resolved that the committee notes the mistake and agrees to regularize the approval request submitted to PMC listed on 20 December 2017. Point 8. That the committee ratifies the PIC's participation in IO's private share placement of 4.3 billion to acquire 20% of IO at 43 rands per share ahead of its listing on the JSE.
The problem with that resolution, it does not capture the conditions precedent that is reflected in the resolution that you signed in the after deliberations with Wilna Low on the 20th of December. Is that not correct?
It's correct, Chair. This doesn't capture the conditions that were placed.
Was it, I know you were not there, do you know whether it was disclosed to this committee that there was an irrevocable offer signed by Dr. Machila on the 14th of December?
Thank you, Commissioner. Yes, it was disclosed. If you refer to point 4 of the resolution, it actually indicates that, again, I'll read it out. On the 14th December 2017, following discussions with the Executive Head of Listed Investment, Investment Management, Legal, and Risk, the PIC Chief Executive Officer signed an irrevocable undertaking to purchase 99 million shares, so I'm not reading out the exact number, shares in IO for 43 rands per share for the total consideration of 4.3 billion, acquiring 29% of IO.
Is that factually correct? The reason I'm asking this, is it factually correct that he only signed this irrevocable undertaking after discussions with the people listed in paragraph 4?
Personally, Chair, I can't confirm exactly, but I can just take the people who've appeared before the Commission where they have deliberations and when the actual reports were completed. So I can't confirm to whether did they have a verbal discussion or not, because I wasn't present.
Was this fact disclosed to the board of the PIC? And I'm asking, perhaps I should a timeline on it. Before the appearance of the board before SCOPA in 2018 December.
So maybe to provide an answer and provide background, if we recall, I'm not sure if it's appeared before the Commission, what gave rise to this resolution was actually an audit finding, which was discussed at the Audit and Risk Committee, which then, if I recall the discussion, they said it got referred to the Investment Committee, which then Investment Committee. So those are the events that preceded this resolution. So this matter had served before the Audit and Risk Committee and Investment Committee. So I'm not really sure that how they report back, because Investment Committee and the Audit Committee report back to the board.
Were you at any board meeting present when it was disclosed to the board and discussed by the PIC board?
Like I had, so I think the disclosures happened between around May, the discussion. So, and the only time I attended the board meeting was to deal with regards to the James Nugu saga. So I'll have to go back and see what was on the agenda that day, because I just attended to deal with the James Nugu parts of the board meeting.
Were you part of the team that composed the report to SCOPA in 2018 December?
Yes, I was part of the team. We had created a team that was putting together the presentation.
And was this fact disclosed to Parliament?
So if you refer back to the memo that the deal team had prepared for the report, they did not include that. And that was a memo, I think, that was prepared by Mr. Siane and approved by Mr. Madavu. The work that I was directly involved with in terms of that, it was putting together the PowerPoint presentation that would have been presented to SCOPA.
Were you present in Parliament during this presentation?
Yes, I was present in Parliament during this presentation, and maybe just to further, and hence why after this and the discussion that resulted in the then chairman of the board requesting that this investigation be carried out.
The most crucial mistake made in this whole IO deal was not disclosed to Parliament.
I agree they should have disclosed to Parliament.
Do you know why?
From the document, and I think in trying to understand what transpired, I think the deal team indicated that the document they had prepared for submission to IC was just consistent with the document that they had, the document, sorry, apologies, the document that they'd prepared for SCOPA, which was an annexure, was done on the premise of the same disclosure which they'd done to IC. So they just duplicated what they'd already disclosed in IC, and I think it already transpired that in the IC of May, that the part of the irrevocable being signed was not disclosed.
You saw no need, as the Chief Financial Officer of this organization and a board member, to say to Parliament, this is what happened with this deal. The signing of this irrevocable offer was not disclosed to me when I chaired the meeting on the 20th of December 2017. You saw no need to do that.
So through you, Chair, I think so no need is like, so what was the purpose of that meeting? It was a report back, and Matshepo More seeing no need. It was not that I saw no need. Everybody was accountable to their presentations. Even the board who was present, even the audit committee that had the deliberations and regarding this were present. So that purpose of that meeting was purely to report back on specifics, and the document, specifically even for that, I even requested the chairman that each executive head will attend the meeting and will present their section because they are accountable to that section. If you look at the timing of that presentation, I think it happened between the 5th and 6th, I'd highlighted to the chairman that I've just been appointed acting CEO, and I'm just still trying to familiarize myself with what has happened, because there's also a period in that financial year that I was not there. So everybody was presenting their stuff and they were accountable because of segregation of duties.
I have no further questions on the IO transaction, Mr. Commissioner.
Did you realize at any stage, let's say after or at the time of the ratification meeting, that there had been an irregularity here?
Through Commissioner, just to make sure I understand, irregularity in terms of the PMC meeting of 20 approving no, Chair, by the time...
Irregularity in the sense that the subscription certificate or agreement was signed before the PMC meeting, and it was, not revealed or placed before that PMC meeting?
So the revealing to PMC members, Chair, regarding the irrevocable being signed took place when this resolution was presented. That prior to that, they hadn't disclosed it.
Can you just repeat that?
So the revealing to PMC members that the irrevocable was signed on the 14th only took place on March 2018. Prior to that, there was no disclosure by the investment team regarding the irrevocable.
Did you then realize that, well, there has been an irregularity here?
If I was present, I would have identified yes.
No. After you now came to know that this certificate was signed before the PMC meeting, do you realize that here was an irregularity?
So, yes, Chair. So there was an irregularity. Yes, I did realize there was an irregularity, and my understanding was that it had served before the IC and the audit committee, and they deliberated on it.
You didn't find any necessity to place it before the board. First board meeting thereafter, after realizing there's an irregularity here.
So, Chair, so the irregularity, I returned to work, I think my first board was around September, I can't recall exactly. So, my understanding, this matter was reported to IC, and IC would report back to board. So it was already within the subcommittee of the board who have a responsibility to report to the board of the outcomes of their meetings.
And did you follow up and try and establish whether that had been done by the IC?
No, Chair. I did not follow up if the IC reported to board.
Can I ask a question on that and then come back to some other things? Commissioner, anything from you? No? Just in relation to that, you had Victor Siani's email, which you hadn't read before the 20th of December, but you then subsequently read it, and you should have, I would have understood if you'd read it at that point in time, been aware that there had been this signing of the irrevocable at the 20th or the 21st of December when you read Victor Siani's email. Would you not have had that information at that point in time when you read his email? Or did you not read his email?
So if you recall, Chair, the email what I was highlighting that I read on the 20th, it's regarding from the Office of the Company Secretary.
No, I understand that,
Okay.
but I'm saying that you got an email that you said you did not open because it was not addressed to you at that point in time, which was on the 19th of December, which included the fact that there had been this irrevocable. Is that correct?
So, Chair, just correct. No, not correct. So I read the email, but I didn't open the attachments because if you refer to my statement, I highlight that the irrevocable was signed as an application form, and that email transpired around 15:52 on the 19th. So it was a discussion about opening up limits. So it had nothing to do with the approval process. It was just about the implementation.
I'm just asking you about whether at that point in time you did not know about the irrevocable. At what point in time did you find out about the irrevocable?
Like I highlighted, I did not open the attachment that said application form. I discovered about the irrevocable upon my return.
In September 2018. So until then, and during that period of time that you were on maternity leave, given that you were, I'm assuming, because I don't see, I mean, obviously one's busy when you have maternity leave, but did you ever go to the office?
Yes, so I did go to office to attend a board meeting. I think it was 2 board meetings. There was a one time which when I deliberated with the head of internal audit was where I'd received a phone call from the chair of the audit committee where they were just saying they had a deliberation because I think Dr. Den was not present. So they never provided me with much details, and I think that's when Mr. Lufuno was presenting it. So they didn't provide me with details regarding the questions in terms of why they had called me.
And during that whole time that you were on maternity leave, between December the 20th and September the following year, did you receive any communication or correspondence or minutes to look at of any of the meetings that took place?
Okay, so maybe I'll answer. So was my mailbox working? Yes, it was working. So what during that period would happen if the then acting CFO would need for me to read something, he will then highlight. So let's give a case in point. So
Now, give the case in point relating to the irrevocable.
So regarding
So the meeting of the meeting where this took place in May, was this one in May? This hasn't got a date on it. Yeah, May. That disclosed this irrevocable. You would not have seen any of that, and you did not get any communication in that whole period about the IO deal.
So no one was sending me directly communication. But maybe I need to highlight. I guess this would have sat in the board pack, which is the system of the company where the company secretary keeps the document. But I didn't open what was discussed in the SATA meeting, Commissioner.
Okay, so during that period the documentation would have been available, but you were on maternity leave and you did not look at it, and therefore the first time you saw about the irrevocable, notwithstanding how important this was to the deal, nobody drew it to your attention as the CFO during that whole month and almost 10 months.
So, Commissioner, I think the most important part is that what would happen is the implementation of conditions and the report back. So no one interacted with me except where I said the audit committee chair had called me. No one interacted with me regarding the happenings of IO.
Okay. Can I then go back to your statement 611 for the investment case, and you set out there all the things that were presented at the time. So we're dealing with the things that were presented at the time as to the key considerations that the committee took into account in looking at the investment case. If you looked at the 611-422, the envisaged acquisition of BT SA by IO, which would have given a significant advantage. Were you, or when did you find out that in actual fact this was misleading in the PLS and in the final statement, because there was actually no such deal and there was no agreement about this?
So post that, the deliberation that we had, I had where I was actively now trying to find out what happened. There was a point where there was a leak, I think, in the media, and then when we were preparing for appearance in court regarding the compliance notice that the CIPC, that's when we were having discussions now to say, clearly this misrepresentation that was made by IO with regards to information, and that's when we were deliberating that, and I guess sitting with the head of legal to put together to say what would be the legal case at the PIC. Even during that process, just before the expiry of the put, I did sign the letter that was notifying IO that we have the intention to exercise the put.
And if you looked at the 424 there, were you aware that this was related, buying the BT shares at 1 billion rand, which would have come out of the funding of the PIC? Were you aware that this was a related party transaction and you were basically buying BT from company A to go to company B in the second Jalo group? And was there any independent valuation made by yourselves of that 1 billion rand, or did you accept that that was the valuation?
So were we aware? Yes, we were aware, hence the condition of that we also must have a conflict of interest related party policy.
Yeah, but that was future. You said
Yes.
you wanted yeah, but this was something that you approved. The 1 billion to be used out of the funding raised for a related party transaction at an inflated price that was set by the group to say this is worth 1 billion rand. Was that what you agreed here?
So at the point of deliberation of 20 December, Commissioner, we were comfortable with what we were approving regarding that the first 1 billion rand of the acquisition, the first 1 billion rand of the private placement will go to BT because the team had indicated that they've done work.
But the question is, did you look at any valuation other than what was presented? Because you know, did you know what they had paid for the share in the first place?
So
I mean, if you looked at it to say when you had this discussion, which you said was a vigorous and robust discussion, was there a questioning of how did the 1 billion rand valuation get determined? Because if you look at a valuation, you've got to say, what did we pay for it? What is it worth now? Why is it worth that?
So in the deliberation, we did not discuss.
So you didn't question the 1 billion?
So we didn't question the 1 billion. We questioned this. If I recall, one of the key things we questioned was, did the team do sensitivity analysis?
That's a different question. The question here was, did you look at and query the valuation of 1 billion rands worth of a purchase? No.
No.
If we come then on to the question of your conditions precedent, which, if you looked at, is 611.8. You could only use this in 8.1. All the funds raised from the pre-listing will be used only for acquisition for growth. This was to ensure that capital was used to fund organic growth and acquisition pipeline. Would you feel that the BT acquisition of 1 billion rand fell into that category?
Yes, it did, and maybe to
even though it already belonged to the group?
So if you refer to another condition we placed later on, when we do the 10%, you will see that in that resolution we explicitly excluded BT because we already looked at BT as a foregone deal. So it was relating to all the
All
future.
other deals?
Yes.
Okay, because your 2 does say that excluding BT, but that means that you accepted that, as you've said earlier. Then you look at the put option, which should be in place. And we've gone through that, so I don't think we need to go through it again because it was not implemented, it was done much later, it was at a price that was questionable, etc. So the question I would ask is, when you looked at Malik Salih's statement to us, and his response was, on the day before listing, that would have been on the 20th, the day of your meeting, Siani had proposed conditions precedent to IO and to AEEI, both. His response, Salih's statement is, Abdullah said I should not respond, we could deal with it in the new year as the signed irrevocable subscription had already been received on the 14th of December. So in essence, they're saying your conditions precedent didn't mean anything to themselves, and you could see that in the discussions and the presentations by Malik Salih, among others, that it was very difficult to have a meeting. The PIC had difficulty getting a meeting, getting discussions going, and getting conditions fulfilled. And that puts me to the question of how would you have conditions precedent? And you, in your comments here, say, well, is it conditions precedent? It wasn't clear in the I'm sorry, I'm just getting to where you talk about it. Because the resolution wasn't clear, the issues were not clear about whether they were conditions precedent or not. This is on 611.9. And if you say that the wording used in the resolution, the minutes, is not explicit on whether a particular condition is a condition precedent or a post-transaction condition, but throughout you refer to it in essence as preconditions. But how do you, and we've seen that in the practice, how do you have post-conditions after money has flowed that have in essence, by and large, because it comes back to your question, the points made about your preconditions, IO appoints non-executive directors, majority of whom should be independent. And there again, there's concern and expressed specifically about, sorry, I've just got to find my different notes. This is, Ms. Adams states that risks were highlighted to the PMC, including that the majority of IO's non-executive directors were not independent, and the 3 board members were closely linked to AEEI, and then subsequently new directors appointed and recommended by the PIC were also shown to have links in various ways, including loans through the Second Jalo Group, if not AO specifically. Did you query the question of independent directors being a precondition or a condition precedent or post, and then seeing whether that was in fact fulfilled?
So the condition, in my view, of the directors is a post condition because it's to ensure that you change the composition of the board. In relation to the comment on the put, like I highlighted...
Sorry, just stay with the board question and
Okay.
changes. Did you look at the directors? Were you satisfied that those non-executive directors were in fact independent in a proper sense?
So if you look at the ESG report, they highlight that the directors are not independent, hence that condition came in to say that you need to make sure that the board is changed and it's predominantly
Yes, I'm
independent.
talking about the names that were proposed afterwards to the board, that the board accepted, that were proposed by the PIC and have been shown to be non-independent from the group.
So through you, Chair, I don't know what date when they were proposing the names.
They've been accepted, they were on the board, they are on the board now as far as I'm aware, but they are not independent, they all have links to Second Jalo, and the names were proposed by the PIC. What I'm asking, that given whether, clearly those are post conditions, in your job, in looking at, on your responsibilities, in looking at the implementation of these conditions, did you consider the names that were put forward, their independence, and whether this was in keeping with the conditions that were set?
So maybe first to answer, it is not, in terms of the delegation of authority and the policies, it's not my responsibility as the CFO, but it is the responsibility that the team implementing the deal team, they need to implement the resolutions. What will then transpire is that at following meetings, the deal team would present to say how they're going about dealing with the resolutions that had been raised by a committee.
So there's no follow-up at a PMC meeting?
So there should be a follow-up because it would be a condition that the PMC had raised. So
And
what
was there follow-up at a PMC meeting subsequent?
I don't have, I'll have to go look at the meetings of the PMC that happened post the 20th of December.
If you could, because was a due diligence then performed as requested? A complete due diligence?
I'll follow up, Chair, just to make sure what were the discussions.
Okay. Okay, I think I'm done.
Ms. More, I'm really worried, and I'll continue to be worried about this non-disclosure, not necessarily by by Victor Siane, but by Dr.
Everyone.
Machila himself, not disclosing at the PMC meeting that he has already signed the subscription agreement or certificate. Did you, after having heard about it, go to him and say, how can you do this? Why didn't you tell me?
So, Commissioner, I never went to him, but I do agree with you that the non-disclosure on the 20th of December, even the non-disclosure to myself, signing the memo of 19, was misrepresentation on the part of Dr. Dan Machila. And at any given point in time, he had a responsibility to make sure that he empowers us and gives us the necessary information. But I'll indicate that I've never subsequently gone to him and said, but why did you not disclose such information when we were busy deliberating the transaction? I haven't. But I do agree it was quite critical that he should have disclosed to the meeting that this had transpired.
I mean, the two of you are virtually the most senior people in the PIC. And didn't you see any necessity of confronting him about this?
So, but I guess, Chair, by the time I returned, this whole deliberation he had been confronted by the audit committee and I think by the IC, which are his supervisor, to say that what you did was inappropriate. And it's my understanding that that's what transpired.
And I take it because of that, it wasn't necessary for you to confront him again.
So confronting him, so I never confronted him, but I would say that I did have the discussion with the team that now we need to relook at the process and what we disclose.
How can that be avoided in the future? How can we make sure that it will never happen again?
So, I think the key critical things, Commissioner, that we need to start doing, and it comes back to when I highlighted more especially the assurance providers, the criticalness of the assurance providers, because I think in terms of the due diligence process, we need to just add that they don't just view the model and stuff, they also check what happens before, so that, because for me there's two processes. There's a process that happens post-investment, and by then it post-approval, but such critical information should be disclosed at the meeting. I think we need to relook at the scope of what the assurance providers are actually doing in terms of the due diligence process, to say that they should highlight and they should look at in terms of, are there any agreements that are signed before entering? So because normally there's an agreement that you could have before PMC being an NDA, which legal would inspect to make sure, so that we need to now start strengthening those processes in the due diligence process in terms of the role they're playing. So you'll see I tend to give the assurance providers, so that in the event the deal team is not disclosing it, because the assurance providers, they provide oversight, and I'll say they're the watch. They watch that they'll come back, so we have to strengthen that.
I'm sure you do remember that Mr. Siane, in his statement, mentioned that Dr. Machilo said at one stage, I am going to sign and then I'll just ask for ratification from PMC.
Yes, Commissioner.
In my mind, it appears that it was nonchalant. I mean, he didn't really bother if what Victor says is true.
I concur with you if what Victor says is true. And I think one of the comments the Commission has made in terms of it's the culture and reviewing. And I think for me, we need to find a way that even if that incident happens, in the memo that the compiler prepares, they explicitly say it. And I'm still trying to figure out how, because it's one of the initiatives that HR is embarked on to start addressing things that are coming out in the climate survey and try to improve them.
Do you think that, or don't you think, rather, that the CEO and possibly the CFO shouldn't take part in meetings considering whether PIC should invest or not?
Okay, maybe let me ask, in terms of PMC or in terms of the board committees?
Well, I'm talking about PMC now. To go and
PMC.
chair the PMC and so forth.
So they've been
Don't you
deliberate.
think that other structures in that process would be sufficient and you two keeping out of it?
So, Chair, it's a difficult question because we've deliberated on it. And what comes out is, now, if we've not deliberated, who gives assurance to the board committees? So how do we deal with that, to say now, when as management there's a submission that's made, as we are not in any way in deliberation. So and the discussion had been whether should we not be members of the IC but members of PMC. And I think one of the key things the PIC needs to start looking at is, and we're trying to do it, and give more delegations lower. Because if you look at institutions, and I've said on other institutions, you do have a delegation where the CEO is present in the meeting. So we need to strike a balance. So maybe to come back to an earlier question that was raised regarding the delegation of authority and agree beforehand. So previously, I can't recall the time, the submission to PMC would have an approved for submission by the CEO. Then we stopped that because of the view that if you're sitting at a PMC meeting and you're looking at a submission that is signed by both the CEO and the CFO, that submission, whether it's approved for submission, it gives the sense that you as the CEO and CFO, you're saying this is the deal that you're supporting. Hence why we even removed. So hence we even introduced the process that, because you'd have had risk that would sign the document of the deal team receives that, because and the fact that risk can approve for submission but not that they recommend the transaction. So therefore we need to start putting the process. Hence it comes back to that part that agreed beforehand, that in practice we were not doing it because of the influence it has, unintended influence that it has, that it would look like we've supported the transaction.
Yes, thank you. I don't know what would be
The
the right thing to do. That's why I'm asking you, what do you think now that it has happened?
Like Chair highlighted, I do think, one, the role, and not just, and I reiterate, not just of the CFO, of the assurance providers need to be relooked at. You have to relook at the structure, you have to relook at the composition of the board committees, even the management committees. You have to relook at the role the assurance providers are playing, and more critical, which one of the evidence the Commissioner had highlighted, is that it is critical that we look at the vacancies and making sure that our recruitment, we are recruiting at the right levels and at the critical departments. So the appointment of the executive head of risk and the appointment of the executive head of legal, for me, it's paramount important. And even the appointment of the general managers inside risk is very critical, and making sure that you are appointing people with the necessary skill set, because those functions are quite critical.
And the chief investment officer?
I've got, like,
Wouldn't that position release the two of you?
so it could release the two of us, but because I've been at the PIC with the CIO and no CIO and stuff, it's a very, so for me, is it an individual? So you can do a CIO, yes, and we were in the process of putting together that we should look into reinstating the CIO. But it also comes back to the question, so if it's just the CIO at the PMC, does not it result in that risk, and you never have a CEO anyway involved in the investment process, and yet he's the accounting officer? So it's one of those, for me, Commissioner, in my personal view, is not a clear-cut answer. You know, there's even been deliberations we had when we took to board that there must be separate, even having CIOs for each asset class, so that you don't have one individual with that ability to go across all asset classes. And that was one of the deliberations we had, that maybe we need to look into that, having a CIO for each asset class, because if you compare the PIC to the market, we are made up of 4 to 5 companies. But as much as most of our, when you just look at asset under management value, but the big part of our AUM being listed, it's benchmark driven, so it's tracking the benchmark, so it's not that active. So that also has to be taken into consideration.
Perhaps just one comment on what you've said, because you've again looked at and said we need to look at things, we need to look at the assurance providers, etc., which may well all be correct and required. But above all, you need to have some kind of regard or respect for the people who give you the documentation. Because what has come through on a number of occasions is that if an opinion is given that is different from what the outcome is required, then the person is told to go back and rewrite the presentation. And therefore the documentation that may end up at the decision-making level has no integrity. So the question for me that I would ask you to, or for the PIC that certainly we will have to look at, is what climate prevails. How, in essence, you have the ability to have a view that is different. And you can see it in Malabatse's statement, for instance, where he says that is something that the CEO, he had never seen something like this in the PIC, and it should never have happened. But did he have the confidence to put that in a document before the decision making? Because he didn't do that. So I'm asking that when you're looking at a review, surely the most important review is the ability to have frank and full discussions, which would mean that people trust their judgment and you trust the people you've put in place. It's no good saying you need to expand the role if you don't rely or take regard or pay heed to what those people are telling you. And that if you have to doubt that the documentation that appears or that is eventually presented is sanitized or met, because until it has met a certain approach, it is not submitted. And that has come through on many of the witnesses' statements, and these are people who are senior in your organization. So I would just ask that perhaps when you're thinking about these issues, you take account of what people have presented at this commission with regard to the climate and integrity of the work that they feel that they can do.
Just as a final comment.
And by the way, it's not a question of reconsidering the position of CIO. Then the MOI says there shall be one.
So just to so if anything, I think the IO, the process of what transpired has been a well lesson learned, more specifically in the listed team. And I think even the notice issued by the CIPC it was a good awakening call, because for the first time the CIPC said this is not limited to directors, but it goes beyond to prescribed officers. And I think, I agree that there needs to be more of the culture, need to be more of the awareness of each and every one of our responsibilities, and clearly identify what is our responsibilities in the process and how it impacts the entire process. Because I do agree, it's not nice to now start thinking if the document that's before you, is it telling the truth, is the conclusion somebody who's tampered with it, which is the things that has transpired out of the commission.
Well, I would think that this is certainly, the whole objective of this commission is to look at the impropriety that occurs in the PIC. There are counterparties to that, but the purpose of the commission is the working of the PIC. And I also then would want to ask the question that as leadership, one of the things that has come through is the role of leadership, and you have 2 executive officers that are the key players in the team, and a view on how the accountability rests with those 2 people, yourself. We're not talking about the incumbents, we're talking about the office. That the role of that office in taking responsibility and accountability for the entirety of that organization and its function. Others may have defined responsibilities, but if you've got 2 executive officers, that's where the office of those 2 people becomes critical, if that's what remains. And I would just think that that is something that if you are considering matters, you need to look at very carefully as the responsibility and accountability, not in terms of who is the accounting officer, but how the PIC functions in relation to its integrity and its roles and responsibilities, because that's not come through very well.
So, through Chair, just as a comment on that, and the comment made by the Commissioner, for me it's the response. You've got 2 executive directors, but because of segregation of duties, the other execs and SMs are critical. So I do agree
that is the functioning
of the process.
That's the functioning, and in every organization there's separation of duties, but there's also clear responsibilities that lie at the helm, and that does not detract from the need for segregation of duties or accountability right the way through the organization.
So through Chair, so not to maybe get just my comment is, and maybe to give context why, when it comes to AUM, all the people, the investment professionals that are part of AUM are actually representative in terms of fires. And if you look at employment contracts, they all have an addendum that highlights the duty of due care and stuff. Hence, for me, my worry is if we just keep isolating it just to the 2, it then tells the rest that you don't need to be accountable. And it's quite important that we all are accountable. We all understand that in the combined assurance model, we're interdependent on each other, and that all of us should do. And I guess that's why it comes to say the criticalness of reviewing the culture and making sure we all are taking in and recognizing that we're taking in it or to what our responsibility is and how we feed in the process. So I agree.
Absolutely, there's no disagreement that everybody has a responsibility and accountability, but there are some people who are more accountable than others because of the virtue of the position that they hold. They hold that office that carries greater responsibility. And that's the part that I find missing in what your testimony has been.
It would surprise me if I was a member of the board of the PIC, if the board wants to ask something with regard to the finance position or financial position of the entity, for me, sitting in your chair, to say, that's not my responsibility. Go ask somebody else. I'd be very surprised if that were to be the case.
So, Commissioner, let me understand. If the case is, if someone asks me about the finances of the PIC.
At board level, you see, you've been telling us that that's not my responsibility, that's someone else's responsibility, either the manager or whoever.
So you'll see, and because the board is ultimately the one that approves the delegation of authority, they then are privy to what they've delegated powers towards me. So you will see even I will discuss more when I'm acting in terms of the CEO, but if you refer to board meetings, you'll see I'll always be the one that's presenting financial statements, being that is this direct delegation that's been given to me by the board in terms of that's my direct responsibility. You'll even see in the front page of the financial statements of the PIC, it is indicated that they are prepared under my supervision. So there is that what is actually my role, and you'll see that even the board had asked that more of the, you remember, I think Mr. Makula raised that they feel that they're not talking to my, that now the board will have a situation when they're getting the heads to be actually talking inside the board meeting, and that the board meeting is not just about the executive director presenting, but they also get to hear from the other EXCO members who are accountable for the day-to-day running of their subsection.
Can I just ask you, I've just had a message that I must request from you. Why were you at the PI offices a month ago when you were on suspension, when regrading was discussed? I don't know if it's true or not. Can you help?
So during my suspension, and I don't know when regrading was discussed, so part of the conditions of my suspension is that if I need access to information, it has to be pre-approved. And then I have to come to the PIC under supervision. The one day that I was physically at the PIC was a day that I had requested permission to have access to my laptop and my phone, which was approved, I think, by the CEO to permit for me. Given all the noise that had been happening, all the subsequent access to my laptop, I then requested the PIC that can I not go to the PIC, but can I actually be at a neutral place, just to make sure that such don't happen, because I'm not privy to what the activities are on that day, and it just becomes a day that we've agreed with the PIC that I can come. And even if you go back, they'll show you that I got to reception, I was escorted to the 7th floor by the head of HR, and I was told to sit in my office and not move, and all the people who needed to provide me access to information would provide me access to information. So I didn't go there for regrading. If there was a day regrading was discussed, that was a coincidence.
Thank you. Then on my last question again on the AO thing. After this audit query was raised, why was there no action taken against, for instance, a person like Victor Siani that you now state deliberately misrepresented facts to the meeting of the 20th of December?
So maybe the key things is that if I reflect to what the internal audit finding, so it was about the 14 of the irrevocable being signed. It only transpired through the subsequent investigation, things like when were the reports submitted, when all of those only transpired after there was a request for a deeper investigation taking place. And I think the internal audit, internal audit report has issued the final report, which you've given me access to.
You see, what is a matter of great concern for me is that I was phoned yesterday by a young man, Sylvester, at the PIC. He compiled the environmental, social and governance report in December 2017 for this meeting. He's a young man. He was pulled in to do this on an urgent basis. And I must say I'm quite impressed with his report. And he filed a very negative report, and I found a word that I've discovered only yesterday. The worst rating in a report is laggard, L-A-G-G-A-R-D. It's in red. And his rating of IO in this SEG report was laggard. It was below 45%. It was in fact 44%. Notwithstanding this, he was yesterday served with charges relating to a disciplinary hearing because he compiled this report. Do you find this fair or just?
So The chair, I'm going to answer it in a different. So, I was privy of the first draft report that internal audit prepared in December 2018. Then, in preparation for the commission, I'd asked the evidence leader if he has access to the final report that was prepared by internal audit. So one of the tasks that I did for myself was just to compare the two reports, because my understanding was that post the draft report, no one was further interviewed. Now, coming to the question that is it fair? There's certain discrepancies between the two documents that concern me personally. So, and I tried to articulate them. So the draft report used to have mitigants. So it will say, Sylvester prepared the document, but this was due because, there was an instruction and stuff. The mitigation should be that is the responsibility of the deal team. Those sections have been removed. So now that document no longer has mitigants that takes into consideration, and if you take the draft and the final, no longer has those mitigants that takes into consideration the circumstances in which someone like Mr. Sylvester would have actually been under in considering the charge. Get into it this way. So I can't talk about into detail internal audit report because chances that I'm also going to be one of the people that has been charged that, and I think yesterday you kind of like highlighted a charge that they had not yet. But I think it's going to be one of the deep discussions that are going to happen inside the disciplinaries to say what was the rationale of changing the report like that to the final, that you remove mitigants, which you would see if the mitigants was there, someone like Sylvester would have not been charged because you have to take into consideration what transpired when he was requested to do the transaction. So you'll also see in the report that the internal audit has changed some of the findings, and specifically when I was reading the report, I was looking at it in terms of my submissions. You'll see in my submissions, previously in the first draft, there were mitigants that were included to say, Mr. Mavuka confirmed this information. That has been removed. So it's now been rewritten in a certain way. And when yesterday through the commission, I heard certain charges, in my belief, it then linked to say the section that's been rewritten has been rewritten to give effect to the charges that are in place. So I don't want to discuss too much, but I was just a high level to say. So I guess I would understand why Mr. Sylvester would be very unhappy about what has happened, because it then appears, which the report will be the basis of any charges, then it then appears that the mitigants that are in place have now been omitted from the report.
Advocate Lubber, can we find out from the PIC in relation to all of the issues, but particular this meeting of the 20th on IO, how many people who are in that entire line of responsibility who submitted any document, how many people have been charged, disciplined, or removed from office or their position, or put on suspension in specific terms in relation to this, and whether there are any pending charges against anyone who has appeared before the committee or submitted information around this. And then the second question would be, perhaps if you can have a statement from the internal audit as to the nature of the change in the final report from the beginning, and whether there was any undue pressure or influence to change his report from the initial draft, because removal of circumstance is quite a significant or material change to an internal audit report.
It's noted through you, Commissioner.
The Commissioner.
I think if there are no further questions, you can carry on.
Number 7, Commissioner, which is on page 35. So it's the alleged frivolous and wasteful expenditure relating to the office move to mainland Maine. My understanding is that I've been requested by the Commission to deal with the matter relating to the office move to mainland Maine, mainly due to the allegations that were made.
Can you speak closer to the mic,
Closer to
or
the
Advocate
mic.
Lubber, if you can switch yours off?
Okay, so should I start
Thank you,
from the beginning?
Commissioner.
Okay. So it's section 7, page 35. Alleged fruitless and wasteful expenditure relating to the office move to mainland Maine. My understanding is that I've been requested by the Commission to deal with the matter relating to the office move to mainland Maine, mainly due to the allegations that were made by Mr. Shield in his statement dated 12 March 2019, as well as during his testimony before the Commission on the 12th and the 13th of March 2019. To the effect that, amongst other things, the PIC has incurred fruitless and wasteful expenditure which has not been disclosed. Based on my reading on the statement of Mr. Shield, as well as the transcript of his testimony before the Commission, my understanding is that Mr. Shield made numerous allegations and/or insinuations relating to the alleged fruitless and wasteful expenditure in respect to the office move. I do not intend to deal with each and every allegation or insinuations made by him, and this should not be construed as an admission of any such allegation and/or insinuation. Should the Commission request that I address any specific allegation, I am more than willing to prepare a supplementary statement in relation thereto. I wish to confine my statement to the following pertinent points which emanate.
Sorry. I need to go somewhere. I need a comfort break. I need a comfort break, so can we take a 10-minute adjournment?
Thank you, Mr. Commissioner.
So we'll adjourn until 25 to.
testimony. Allegations and/or insinuations pertaining to critical matters which are factually incorrect. Alleged fruitless and wasteful expenditure in the financial statements. Alleged handpicking of interior designers, and alleged ill treatment of the Office of the Auditor General. Before I deal with the above issues, I would like to, firstly, highlight the circumstances that were prevailing when Mr. Shield prepared his statement, as I believe such circumstances provided a context within which Mr. Shield's allegations are made. And secondly, outline at a high level the critical events that transpired in relation to the planning and the preparation of the office move. Circumstances prevailing when Mr. Shield prepared his statement. On the 23rd of January 2019, Mr. Shield was charged, among other things, non-compliance with the PIC procurement policies in the engagement and/or appointment of a service provider. I attach here too a copy of the notice of a disciplinary hearing marked Annexure MM51. Following a hearing chaired by the independent chairperson, Mr. Shield was found guilty of 2 of the 4 charges that were leveled against them. In relation to non-compliance with the PIC procurement policies, the chairman recommended dismissal of Mr. Shield.
Can you pull your mic slightly down?
Yeah.
That's right.
I attach here too a copy of the recommendation of the chairperson of the disciplinary inquiry, marked Annexure MM52. It is to be observed that the chairperson found that the fact that Mr. Shield refused to take corrective steps in relation to his non-compliance with the PIC procurement policy is in defiance of instruction from his superiors constituted an aggravating factor. I wish to highlight that Mr. Shield alleges that I berated him when I refused to approve certain steps and/or activities that were not in line with the PIC policies and processes relating to, amongst others, the engagement of service provider. The recommendation of the chairperson was delivered on the 11th of March 2019, being a day before Mr. Shield prepared his statement and appeared before the Commission. It is my belief that the motive underlying Mr. Shield's statement and testimony was to utilize the Commission to challenge his dismissal ruling, rather than to genuinely, as he contends, deal with his allegations relating to fruitless and wasteful expenditure. Outline of events surrounding the office move. It is common course that the office move was triggered by the request of the PIC property team acting on behalf of GPF for the PIC to relocate to Mainland Main. The request was made as a result of the FSB requiring additional space in River Walk that was then occupied by the PIC. In order to facilitate the move to Mainland Main, it was agreed with the landlord that it would be a turnkey solution, i.e. the landlord will be responsible for the procurement and provisioning of everything required in respect of the office move. However, the PIC will still be responsible for providing funding for certain fit-outs, for example, lessee-specific features. The source of funding for these fit-outs is the tenant installation amount and the PIC budget for leasehold improvement. The only major condition that the PIC imposed on the landlord was that all service providers must have a BE rating of between level 1 and 4. I do not have details of when exactly the landlord started the construction. I only started getting actively involved in the operations of the project when I, in my capacity as the CFO, had to approve invoices on the project. After the departure of Ms. Daka Petro, which is in May 2016, I then also became actively involved in the office interior decisions. In August 2016, when I had to assist with the allocation of space to various departments, I discovered that the space immediately available for use was configured to accommodate approximately 350 employees, and not all the approved positions in the org structure, approximately 516 employees. I attach here 2 email correspondence reflecting my engagement with Mr. Shield regarding this problem, marked Annexure MM53. It is to be noted that, according to Mr. Shield, space for additional employees was to be created as and when the PIC recruited for the vacant positions, i.e. demolishing offices and converting them into open plan space. Further, according to the plans, the 3rd floor was to be kept as a white box, i.e. remain unfitted, and construction on this floor to begin as and when recruitment occurs. This was clearly unworkable. It would have had the effect of rendering the PIC's office environment a construction site on a permanent basis. It must be noted that the decision to keep the third floor as a white box was not driven by cost consideration, as the PIC was liable for paying for the space anyway.
Just a quick one here. When Mrs. Decker left, were you the next one to look after this, or there could have been junior employees to look at it? Because it looks like you went with some energy into this thing.
So there were junior employees, so Mr. Kwabena Boteng, so being the senior manager of operations, so he did a lot of the interaction. So interaction in terms of construction, and if you ever look at the email correspondence, you'll see he's part and parcel of that. We did set up a task team that was advising in terms of that. So my role was predominant. So my role was with the so maybe just that. So there was active, and then I just had the role of the look and feel.
But you were the ultimate sort of decision maker within that division, or something else?
Okay, so it's, in trying to explain, so not ultimately the decision maker, because you had IT, the executive of IT was the decision maker, you had risk in terms of security and stuff, they were the decision maker. So for me, I informally created like a team of 4 or 5, and I don't want to be sexist, it was ideally females, that will go through the picking up of what furniture it is. Like if you look at the open plan furniture, it was we set out an expedition for employees to pick what they like. So
yes,
yeah.
But who was the final decision? Say the color scheme is right, the chairs are right, I'm signing off on those, you know.
So I'd say I'd sign off on certain furniture, but the open plan was the business agreed what they liked. They had to vote.
Oh, I see. Okay.
Yeah.
Okay. All right.
7.6.7. In light of the problem regarding the third floor, a decision was made to include the third floor as part of the space that would be available for immediate use. This additional work was one of the contributors that prevented the PIC from taking occupation in January 2017. We further identified that there were business space requirements not factored in, such as a prayer room, a mother room, an archiving room, etc. This then resulted in the need to rent additional space to construct such on the second floor.
What happened now? Your voice is right down.
Oh, sorry. In addition, during early November 2016, it was highlighted that not all the required IT infrastructure would be ready in January 2017. This also contributed to the need to change the occupation date to 1st of March 2017. It was also highlighted by the landlord that the construction of the second floor, being the boardrooms, training room and reception, will not be complete by January 2017 due to the builder's holiday during December. I attach here too email correspondence reflecting correspondence in relation to the delays from the IT perspective, as well as an arrangement that was made to move the occupation date to 1st of March 2017, marked Annexure MM54. Through the above engagements relating to the office move with the landlord, I then further discovered that Mr. Shiel, in his capacity as the representative of the landlord and in consultation with the interior designers, had an arrangement with Mpumelelo, being a furniture supplier, to the effect that the PIC will be required to pay Mpumelelo a fee when an invoice is issued, and further that the invoice would attract interest upon issuing. When I required further clarification on this issue, I discovered that Mr. Shiel had committed the PIC to pay Mpumelelo for providing furniture samples, even if they were not appointed as the preferred supplier. I attach here to email correspondence reflecting the arrangement Mr. Shiel entered into with Mpumelelo, marked Annexure MM55. I pause to highlight that these are similar arrangements that Mr. Shiel had entered into in other projects, which resulted in him being subject to a disciplinary hearing and ultimately found guilty. In light of the fact that the arrangement with Mpumelelo was not in the best interest of the PIC, Mpumelelo's scope was limited to providing open space furniture, as they had already started the work on it. I then requested the landlord to procure another service provider in respect of interior design, including furniture, in accordance with the 10-key agreement. The landlord proceeded to appoint a new service provider. I wish to highlight that I was not directly involved in the identification and appointment of the service provider. We were unable to move on 1 March 2017 as initially planned due to the fact that the occupation certificate had not been issued. This necessitated us agreeing with the landlord on a new move date of 1 April 2017. The inspection of the building by the City of Tshwane only took place on the 22nd of March 2017. I attach here too a copy of the City of Tshwane inspection report dated the 22nd of March 2017, marked Annexure MM56. It is to be noted that the inspection was limited to the 4th to 7th floors, thus excluding the 2nd floor and the 3rd floors. On the 27th of March 2017, the Risk Department sent an email to the then acting CEO, highlighting the risks associated with moving on 1 April 2017 as planned. I attach here too a copy of the email correspondence from Risk, marked as from the Risk Department, marked Annexure MM57. It is to be observed that according to the Risk Department, the risks were rated high, i.e. amber and red. It was on the basis of these risks that a decision was taken to postpone the move to the end of June 2017. I further attached the email of the landlord's representative, being Mr. Tantenda Mavunga, dated 7 March 2017, addressed to the construction company Bochadman and Partners, highlighting the fact that the 3rd floor will not be ready at the end of March 2017, marked Annexure MM58. The move to the new offices then occurred in June 2017. I now proceed to deal with the pertinent points which emanate from Mr. Shield's statement and testimony. Factually,
Another question here. So, are you saying the delay happened because of the risks? Because I think, if I recall, he said that you changed the company, one company for the other, in terms of the interior decorations.
So, teacher, just to make I understand, are you asking if the change in due dates was because of change in service providers?
The delay seemed to have been caused by the change in the service providers.
So I confirm that's incorrect. So the change in service providers would have no change in the occupation date. Like I'm highlighting in my statement, that the big drivers that when we moved between we moved to the 1st of March is there was no occupation certificate in place. Then we were meant to move, and IT was not fully ready for it, and for us to move in that the infrastructure was not complete. Then come 1st of April, where we were intending to move, Risk highlighted further that there was issues in terms of construction, in terms of we had no formal boardrooms because the 2nd floor, which is the space of the boardroom, was not complete.
Okay.
Can I just ask you before you move to the next section on that? In this whole process and preparations, how often did you meet Mr. Shield?
So he met frequently because the active team was the task team. So with me, they would have met with the meetings we had. It was when I was inquiring regarding the budget. So it was not an everyday meeting. So it was when I was inquiring on the budget because the invoices were presented before me.
So there was no meeting around the issues that you've identified here where he has a view of what's happening and you have a different view, but there was not an engagement with him per se by yourself in that?
So there was an engagement, and I'm just trying to find the email where he...
No, I'm not asking about one. I'm just asking over this whole period of time with a number of things that have gone on, did you find a way to sit with him or the team on a regular basis to say, let me update you, this is what's happening, this is what your report is, this is where the differences are? You and the team that included Mr. Shield, did you have a weekly meeting, a monthly meeting, or was it only over specific issues?
So if I recall, the team, and I think the most critical thing is to distinguish the two. So there's a team that represent the PIC as corporate. because Mr. Shield represented the landlord. So that team, if I recall, closer to the date of moving, I think it was meeting every week, and they will provide feedback. So the senior manager of operations will provide feedback to me, and my capacity was always about the financial budget, and then I was sub-delegated to deal with the local affairs. So we'd meet with Mr. Shield when there was a discussion with the landlord.
So he wasn't in the loop of the work that was going on in relation to you and the team that was representing corporate?
So he was in the loop. If you refer back to his statement, he highlights that he'd get frequent, even if he's not meeting with the PIC directly, he'll have frequent updates from the consortium that represents the landlord. So 7.7 and page 14. Factually incorrect statements. Mr. Shield alleges that following the email in which I allegedly berated him on the 29th of November 2016, a meeting was convened on the same day to discuss, among others, the new date for the movement as a result of my failure to provide information. I wish to point out that this is incorrect, that I berated him, and that rather I was opposed to him requiring the chairperson of the office move committee to approve things where the budget had not been finalized. Something that was going to be done at the meeting scheduled for later that day. I attach here to correspondence reflecting the discussion held in this regard, marked Annexure MM59. It is to be observed that the meeting was convened way before the 29th of November 2016. Therefore, it is incorrect that the meeting was convened following the alleged berating. Critical facts which were omitted in Mr. Shield's testimony. As pointed out in paragraph 7.6.6 above, Mr. Shield omitted from his statement the fact that the delays were occasioned as a result of his failure to ensure that the total head count of employees was factored in when calculating the space to be immediately available for occupation. This failure occurred despite him having been provided with the head count as early as March 2015, as per the email correspondence attached here to marked Annexure MM60. Alleged fruitless and wasteful expenditure in the financial statements. It is incorrect that a fruitless and wasteful expenditure was incurred in respect of the office move. For an example, for an expenditure to be fruitless and wasteful, it must have the elements of the definition of this concept as set out in Section 1 of the PFMA. In terms of the definition, fruitless and wasteful expenditure is expenditure made in vain and would not have been avoided had reasonable care been exercised. In the preparation of the financial statements, the finance team prepares an assessment to see if any expenditure incurred meets the definition of fruitless and wasteful expenditure. I attach hereto, for illustrative purposes, a sample of a memorandum that is prepared in relation to the assessment of whether an expenditure is fruitless and wasteful, marked Annexure MM61. The expenditure that was incurred in respect of office move to Mainland Main was found not to be fruitless and wasteful expenditure as contemplated by the relevant legislation. The treatment of this expenditure was also accepted by the Office of the Auditor General. In this regard, I wish to highlight that the Office of the Auditor General raised this issue in their draft preliminary audit finding document. Following written representation from management, clarifying the circumstances under which the expenditures were incurred, the finding was cleared from the final audit report. Alleged handpicking of a new interior designers. I refer to the processes that were followed in appointing new interior designers and the reason thereof in paragraph 7.6.11 above. I wish to place it on record that prior to their appointment, I had never met nor did I know any official of the new designers. Therefore, Mr. Shield's allegation that the interior designers were handpicked by me are baseless, disingenuous, and defamatory. I further wish to emphasize that the PIC was not responsible for the appointment of service providers on the project, as this was a turnkey solution and therefore the PIC procurement policies were not applicable. Alleged ill treatment of the Office of the Auditor General. Mr. Shield alleges that the audit team from the Office of the Auditor General was open quote, treated with contempt and in most cases sent packing in no uncertain terms. Mr. Shield's views based on the fact that the Office of the Auditor General did not consider the expenditure of the office move to be fruitless and wasteful, as he wanted them to so rule. I refer to the process that the Office of the Auditor General followed in relation to expenditure, as outlined in paragraph 7.9.4 above. In my view, these allegations are grossly baseless. The Office of the Auditor General was afforded all necessary cooperation and access during its audit process.
Thank you. I have a couple of questions regarding this last topic. You've also stated that it must be clearly understood that Mr. Schill, in this whole process, acted on behalf of the GEPF as the landlord. Is that correct?
Correct.
I'm not going to dwell on his disciplinary hearing. He has taken the matter further to the CCMA, and his defense is that he was dismissed on trump-up charges. So I'm not going to discuss that. It's going to go to the CCMA for further adjudication. I deal with 7.5.3. One of the reasons Mr. Schill stated for the late move was that the IT people were not ready. Is that correct?
That is correct.
In 7.6.6, we deal with approximately 350 employees. In his evidence, he pointed out that you approved the plans. Despite what you may now say about potential disruption, the plans in the form as described in his evidence were approved by yourself on the 27th of June 2016. Is that correct?
The Commissioner is correct, but I think I need to highlight plans is how the floor plan will sit.
Yes. And he again reiterates, and he asked me to put this on record here, what happened to the space on the second floor given the business requirements of the PIC? Does it not until today remain vacant with no work in progress despite more than 2 years passing?
So currently it's vacant, and I think it's just awaiting for a commencement of construction and final approval.
So it's correct, it's vacant for more than 2 years?
So is it, yeah, it's correct.
The other point he makes, as development manager, did he have any authority to appoint any service providers?
So if you refer to one of my annexures, which was when I inquired up regarding the appointment of Mpumelelo, and the email correspondence, I'm just trying to find it for you. The email correspondence highlights that, it's annexure 55. The development manager that was responsible for the consortium, being the group, highlights in an email on the second page that, and he responds to an email which of the 12th of December 2016, which says, Alvin, can you please urgently respond to the queries below, as this process was driven from PIC side. So in terms of the turnkey, the responsibility was of the landlord. And the landlord is not just PIC, but it's the group, the consortium. Hence why, when I tried to inquire to say, okay, why are the costs going up? Then they highlighted that the main developer for the whole precinct highlighted it's because of an arrangement that was entered into, which was done on the side of the PIC. Hence, the final the outcome was that they have to comply with the 10 key agreement, that all these things should result inside the consortium and not just individuals.
It says, is it not correct, Menlyn Main co-ownership was requested by PIC as confirmed in the signed offer to provide a turnkey fit-out. That is, you walk in and everything is done and ready to go. Is it not correct then that the selection of Impumelelo was in fact the appointed architect's election as opposed to Mr. Shields?
So through you, Commissioner, I can only, if I'll refer back to that annex chart, that you would see that there's discussion where the main development manager of the consortium says, I don't know how these guys were appointed. And these were appointed by PIC, by Mr. Schill himself. And that the discussion was that the contract with Mpumelelo was not in the best interest of the PIC financially, because it meant every time there was an invoice, and I think there's an email that indicates where the provide explanation will incur costs. And as highlighted in this email, is Annex 55, Alvin had said this was appointed by the interior design. No, correction, he says Mpumelelo was recommended.
Yes, and his testimony is also that Mpumelelo was also previously used by the PIC and the GAPF in a project. It's not that they were now suddenly a new service provider.
So through you, Chair, if you refer to Annex 55 and you refer to page 4, you will see when the team are trying to explain to me why the cost for Mpumelelo and why Mpumelelo was used, I highlighted to them that the reasoning is inconsistent. They are giving me different versions of why Mpumelelo was appointed. So if you see, I say Mpumelelo, I hear the reason for procurement, but it's invalid, because if it was the case, why the other quotes are requested? So there was always a variation of why Mpumelelo was selected, and therefore the primary reason why we didn't go with Mpumelelo was the agreement was not in the best interest of the PIC.
But that was an appointment by the consortium, and the invoices were received from the consortium.
So, through Chair, if you see, the consortium actually says we inside the consortium together did not take ownership of that. That was driven outside of the PIC. So hence why I reiterated to the consortium that every decision needs to be made by the consortium, not individuals outside of the consortium.
The last point is the point made by Mr. Schill that the additional costs that were paid for the late move were absorbed in the financial statements to disguise it and not to show it as fruitless and wasteful expenditure. You mentioned that the AG picked it up. Was it on the basis that the AG also considered it as fruitless and wasteful expenditure?
So through you, Commissioner, just to highlight, so at any given point, the AG would raise an audit finding, and when we'll need to provide additional information and provide an explanation to the Auditor General. So if we had numerous audit findings and we provide addition, so they'll identify an audit and will provide additional information which then clears the audit finding.
Yes, but the point is that the AG also thought this was fruitless and wasteful expenditure initially.
So the answer to that, no. So their fruitless and wasteful related to their finding related. So they assessed fruitless and wasteful across the office move. They identified fruitless and wasteful relating to the river walk.
Thank you, Mr. Commissioner. I have no further question on this topic.
Yes, I got final questions since you are here, so I thought you were close to the end, I think. Yeah? All right, so good. I got broad questions, general questions about 3 or so, and then I got about specific ones, 3 or 4 questions. All right, there. The first one, we have asked this before, so please, if you can, try to answer that. Who is James Nogu, Like, if you found out you're on the board and you are a senior person there. What's your speculation? What you are thinking? Who is? Sorry, what is your thinking? Is it? Yeah. Who is James Nogu? Or who are James Nogus? Because there could be more than one.
I'd hope the commission will come out with that answer.
Yeah.
My speculation is, when I look at Nogu versus Nogu, I just think maybe it's two different people. I think it was a coincidence that Nogu and Nogu there was missed. So I've tried not to speculate to say who it is because it will create a culture of distrust, and it's for me. So I don't know who James Nogu is. Nogu, or PIC Shield, or whatever name he or she refers. I almost said he or she or the group represents.
Could it be employees, directors outside the PIC around that one?
It could be a mix, Commissioner. It could be a mix. It could be a mix, and it could also be a mix of people who are not well informed. So I'll give an example. One of Lito, and I've assumed it's actually the Sotho version of PICI being the email which James Nogu once used, would make the mention that, I'm colluding with the auditors being Deloitte. So that's clearly somebody who doesn't know the PIC because the PIC is audited by the Auditor General. So, it's a very difficult one.
Okay. Let's leave it there, I guess. Yeah, let's leave
But
it
I
there.
do hope the commission comes out with who James Nogu.
Yeah. Well, we'll see. And then let's talk about the board, because you were on the board there. I think it was Miss Manning or Beswick or the other ones who said that pre-Nogu emails, the PIC was a peaceful place, all right? After that, then there were problems, and the board in some ways got fractured. What was the experience after that? Was the board fractured and very, very divisive and all that?
So Commissioner, I think the parts of the board that, if I read into what took place, that resulted in the words you've used, fractioned or whatever, were parts that were deliberated in camera. So I think it was how the James Nogu, because if you refer to the minutes, you can see, and if I think about the time we were recused, I think that it put a long deliberation in that. So not knowing exactly the context of what they're fighting on, so you'd have those, and I think there was fractured. So when it came to certain issues, like the standard, they worked together. So the mandatory, and I think maybe the cause was this was the first time PIC was subjected to such. So maybe we were not all well prepared onto the events that took place after James Nogu. And I think the one other thing that didn't help is that almost every year we're having a change in chairman. I think that also doesn't help in terms of continuity, in that you have to go back, different approaches, different stuff. So I think that also might have added to just confusion. But I think the big thing, it was the big issues that were in camera, and I was not privy into the meetings when they deliberated them.
And tell me then, if you were a chairperson in a board which is fractured and factionalized, and then you go to vote to make decisions, how would you tackle it? Do you think such a board can ever recover?
Sorry, just to...
Factionalized, you go to vote to make a decision, no consensus and all that?
Well, there's one important issue the commissioner, I'm going to use it, the commissioner as he raised, that, you start worrying about the documents and stuff. Will it fully recover? No, they will never fully recover, because I think maybe the embedding, it will always be what is your ulterior motive into this. So things that previously just looked black and white, people will start thinking maybe there's a gray color in between. So it will never fully require. I think for me, what is critical in any given point is they must remember their fiduciary duties is to look after the PIC. So they must always try to prevail and put that first. And if at any point that it appears that they're not, I think then they need to be reassessed if the combination of the members is the correct combination.
Can a chairperson do something? I mean, if the board has reached that particular point?
I think you can, it's the same thing to say, when there's something incorrect with a culture, you go back and look at what you do with a culture. I think we could look into, and maybe for me, one of the key things, and I know it's EXCO, we had discussed this, maybe let's discuss what is the real problem. Let's put it on the table to say, what is the real problem? And, sometimes it's better when we know upfront what's the real problem, because we then know how to address it instead of running around and hiding it. So I do think there's respective initiatives that can be put in place to try to improve.
Talk, to sit down and talk about it. Is that
Yeah,
what
so I call it, when you go to a place and you say, we're going to beat each other up, but by the time we leave, we're going to be civil and mutual respect.
Yeah. Okay, all right. Next one is, when you look at various transactions, it appears that the bulk of them came through Dr. Machila, and I think one or two other came through you also. Is that correct, that the bulk of the transaction come through the top two?
So I think it's incorrect. I don't think the bulk of the transactions come from the top two, because we've got on our website, we've got the Sibaya system that is there that people can make applications. And nature, they don't just come from the top two, they come from all parts. And sometimes people might just think they come from the top two, but because the chairman has referred, and therefore I then on-refer because of the emails. It's a very difficult one, Commissioner, to always say, we are not allowed. Because what happens is somebody will pick up an email and they believe that if they email it to the office of the CEO, it'll get better attention or stuff. So that's why one of the key things the board had asked that we relook at the system and making sure that the systems are actually working fully. It's the Isibaya application system, because I think you've seen other institutions where the system is working efficiently, and that's why we're in the process of procuring a system for Isibaya.
Next one. I've heard you speaking about Mr. Shiel and say, he was berated by you, and then, as a finance person, probably you say no to people and all that. The question then is, are you a tough lady? Are you like a tough cookie and all that,
A tough cookie. I don't know what's a tough cookie, but I would say...
Yeah, what kind of person are you? I mean,
Yes, I feel like I'm in a job interview. So I'm not... so maybe it's not... I'm not a tough cookie, but I believe, the key is the compliance of policies and procedures. So sometimes that can be misinterpreted as being a tough cookie. I always say to my team, to say, if you look at the irregular expenditure of the countries, the fiscus, it's very big, and the potential of the PIC having a big irregular expenditure is quite big. So at any given point in time, we need to make sure that we've got processes in place to make sure that such is not taking place. And I guess sometimes when you have that, it could be misinterpreted as being a tough cookie. But that is the compliance with policies.
Then I want to ask you targeted questions, from the allegations which came through, to just close out this whole issue. Just if you can take some notes, just to make sure that we cover all the stuff, all right? Yeah. The first one is from Silo Motau with Teco, I think Teco Capital, ne? He said that he was supposed to get a 10% stake in ETG, and you chaired a meeting where you guys said, no, he's not going to get that 10%, it is going to go to somebody else. And he said that you actually chaired that particular meeting. So the question is that true? And why? And what has happened to his 10%?
Commissioner, I'll have to find the details, but I can't, I'll have to get back to the details, what were the deliberations in that committee. But I don't ever foresee a committee deciding a committee saying A versus B, unless the proposal was put in place by the deal team and they had certain motivation. So I'll need to look into the paperwork of that.
It's because this is the guy who served on he advised on the current beef transaction.
Okay.
Yeah? If you could get us an answer there.
Give me the list. Yes,
Yeah,
I will look at
ETG, okay. So,
Okay.
yes. And he said you were chairing that particular meeting that decided that.
Chairing, yes, but I'll,
You
taking
do-
that
you-
fact, I'll say yes,
you'll-
but chairing doesn't mean that I am the one who said.
Yeah.
Just means I
okay.
was,
All
I will
right.
look into that, Commissioner.
Okay, all right. And then let's talk about Sandile Sibia. He says in 2013, if you can remember, you asked him to reduce a score of some employee and to keep quiet about it, for you and him to keep quiet about him. In 2013,
Commissioner, you know that would be impossible
Mm-hmm.
because internal audit will audit the balanced scorecard rating and make sure that they agree with the signed outcome from the moderating committee. The external auditors also audit the incentive, and let's just say it happened, that employee would have lodged the grievance.
then let's go to Ms. Nomza Mopeche, yeah? In her statement on paragraph 34 and I think 36, she mentions that there was a position, I think it was head of corporate affairs, and that she didn't even apply for it because apparently you went to someone and said, why is she bothering, applying for it? And she just decided, since you're going to be on the panel to interview the people, that she's not going to bother because you are prejudging her.
I don't, Chair, that would have never done, and I don't even think I was in the panel. So, because that is the space that's set under the executive head of corporate services.
Yeah.
So I can come back and confirm
Think
that,
about it, yeah,
that
yeah.
I don't even think
Come
I was
back
in
on
the
that.
panel.
All right, okay. And then the next one came from Mr. Magula about Brian Mavuka, yeah? He says that there was a time you disciplined him, and I think when you discipline somebody, they're not supposed to get a bonus or something, but it looks like he got a bonus. Can you recall that? Can you?
No, I'll have to refer that I disciplined somebody and they didn't get a bonus.
Yeah. Yeah, or tell us about the policy. If someone has been disciplined, do they get bonuses and salary increases?
Yes, so the primary, in terms of the remuneration policy, the primary, the one and only factor is your balanced scorecard rating. So if you were disciplined, your balanced scorecard rating will prevail. It would be a performance rating. So the policy does not prohibit such.
The next one is just an old one, like some time back, and this came from Mr. Vuyo Jack, and he said that he was trying to procure something or travel or so, and you said that you couldn't approve the expenditure because it's irregular also. Can you recall that one?
So one of the big deliberations that took place at the board was the appointment of KPMG for the governance review. So one of the issues I highlighted to the board was that, in my view, I believe the decision they took will ultimately be defined as irregular. So as in my responsibility as the CFO, I'm highlighting to them that they must reconsider the decisions because I believe that the decision they've taken will be irregular. Ultimately, that was found to be irregular. the auditors did raise it. So I think Mr. Vuyo-Jack was not present at the PIC when the auditors actually ultimately identified that appointment as being an irregular expenditure.
Then the final one, and please, if you cannot answer, don't answer. It's a bit personal, but I need to ask it, okay? Bantu Lomisa, General Bantu Lomisa came here, and he said that there's a More who's got a loan from the GEPF and all that. And then that you are married to his cousin or so, you know. Can you explain it? I mean, for the house, if you can.
I'll try my best. So it's in the Melrose Arch transaction. There's a Bongani More who was part of the sponsor, so I want to put it on record. I'm in no way related to him. I don't know him in other words, but besides, so it was relating that. And just to highlight, I think in that, the testimony of Mr. To me, he's Tatomling. So to Mr. Olomesa, the General Olomesa, it was relating that it was a home loan or stuff. And I just want to clarify, it's not a home loan. When we put together the BE funding guideline, one of the things we did was to ensure that we have enhanced security. So the security comes with personal surety. So that bond is a notarial bond, actually. It's not a home bond. It's personal surety on the house of the individual that in the event of default will take. And then in explaining, you know, I never know in English. So he said cousin brother, I'll say cousin brother. But I will say in Xhosa, to me, he's Tatomling. So it's difficult. I'm hoping people who know Xhosa will explain that that's who he is to me. He's Tatomling.
And you are married to his cousin?
That's why my difficulty is in English to say, is it a cousin? I'll just concur because that's what he said, but that's why I can only give it to you in Xhosa.
Okay, I don't know because I'm paid, but it's fine, it's fine. Okay. I'll ask around. I'll ask around.
Tatomncinci is usually your father's younger brother, but it can extend to, you know, a large part of the family as well.
One of those in the
Not a
Xhosa.
direct younger brother.
Oh, I see. Oh, I see. Okay, yeah.
It's just to recognize an elder around the father.
Okay. All right. Yeah.
I'm just coming in not to prove that that is the correct interpretation, but merely to indicate, because, you know, the laws of evidence, a chairperson or a judge or a magistrate can't try and correct an interpretation, but rather suggest that isn't this what it is.
Confirmation, it is what it is, what you've highlighted, that it's the broadness.
I'm done. Thank you very much. Thank you.
Just a question arising from your paragraph 710.3 rather, sorry. You say that Mr. Shields' allegation that the interior designers were handpicked by me are baseless, disingenuous, and defamatory. What's defamatory about it?
So I just took offense because it's, and I guess it's you can highlight, just took offense to say, you know, I went around handpicking my own people when he's fully aware of that it was a turnkey solution.
All right, thank you. Is that the end of the day, Mr.
That is,
President?
Mr. Commissioner, that is the business of the day. It was a long day of intense debate. 2 days.
Yes, then it remains for me to say to you, Ms. More, that I don't think that you, in fact, I doubt whether we can say you finished today. It seems to me that you will have to come back at some stage to clear up certain issues. You've been writing down notes on matters that you're going to look at and so on. So you might be called back again at some stage, and I hope you'll make yourself available. In fact,
I will
you-
make myself
you
available,
must make
Commissioner.
yourself available.
No, I will. You don't need to subpoena me.
Yes, yes. Otherwise, thank you very much for your time and
Thank
your statement in which you attempted, and I think maybe succeeded in dealing with all aspects that concern you in the evidence that has been placed before the court. And I'm not saying that you are correct in your dealing with them. I'm not saying that, but we'll make a finding at a later stage down the line. But thank you so much for the time. You must have spent quite a bit of time in dealing with those issues in your 41-page statement.
Commissioner,
Yes, thank you so much.
thank you.
We'll thank you after you'd come again for the second or third time. Thank you very much.
Thank you, sir.
Commissioner, can we then adjourn till 10 tomorrow?
We'll adjourn until 10 o'clock tomorrow morning.